thanks for joining Crystal, Henry, and I to discuss the legal delivery and really prep for what's going to be an attorney-client call with you. The goal of today's call is really to give you a basic understanding and education of some of the documents your attorney is going to go over with you, with the goal that you can jot down questions or comments you have so you can bring those up to your attorney when you're going over the documents with them to make that call really effective. I'm going to hand it over to Crystal momentarily to kind of lay out what we're going to discuss, and then I'm going to cover just a few high-level things just conceptually before we get into the weeds here. So Crystal, thanks for joining us, and you want to lay out kind of what you're envisioning the purpose of this call to be outside of what I've mentioned there and what we're going to tackle today.
Yeah, thanks, Blake. So we're going to talk about the documents that are going to be included in your estate plan. So we're going to go over the main points and the commonalities of the documents, whereas when you are on the delivery call with your drafting attorney, you will go over the more nuanced and specific aspects of each document. However, most of these documents have a lot of certain standard language and common terms and common aspects. So that's what we're going to cover today to make your actual delivery call go a lot more smoother and a lot faster.
Yeah, and I've heard you mention before, Crystal, that some of these documents that are state specific might look different than what you're going to go over today, the formatting, the context, but there's kind of underlying principles, right, that are usually pretty consistent throughout all of them.
That's exactly right. So some of our documents, for example, our trust documents, are Tennessee trust documents. So the document that you're looking at, your document, should look pretty similar to the document that we're going to show you on screen. However, other documents, your core estate documents, the will, the healthcare documents, living will, healthcare directive, powers of attorney, those are going to be state specific depending on where you live. So they might look completely different. There are some states that require statutory forms. So the living will or the healthcare directive might be named something totally different. You might not have a living will if your state doesn't require that. They might refer to it as a healthcare power of attorney. But the main goal of those documents is the same. The overarching umbrella is, who do you want to be making decisions for you in the event you're incapacitated? So we're going to talk about that and talk about the commonalities of these documents. But don't worry if the healthcare document that you are looking at looks totally different from the one that we have up on screen.
That's a really good point, Crystal. So before we get into the nitty-gritty here, like I said earlier, I'll take us through just a brief conceptual review just to make sure that we're all on the same page with what we're going to discuss, but more importantly, how it all fits together. We've discussed in prior videos that the centerpiece of most of what is being set up is a limited liability company that's going to own the cryptocurrency that you, the client, have. In that company, and Crystal will get into more detail on this within the operating agreement for that entity, you are in control of what happens day to day. You are the manager and you're running that business, and you have control and access to the crypto that it owns. The owners of that business are going to be a combination of certain trusts that you may have set up depending on what you have set up, and then you personally. And the reason why I call that LLC the centerpiece is because it truly is what kind of holds everything together that your attorney has drafted for you and will review for you on that call. It is what holds the assets. It is what ties all of the legal entities together. So we're going to go through that and just keep that in mind as we go through it. But that's kind of the centerpiece. We'll start with some of the more basic stuff, get to that entity discussion, and then talk about some of the more nuanced trusts towards the end of this. Crystal, is there anything you wanted to add to anything I mentioned there?
Like Blake said, the operating agreement is the centerpiece, and then the estate documents are going to flow from that. So we'll talk about everything on this call, hit all those main points and commonalities. Make sure you write down any questions that arise, any specific questions in particular. That way you can really tailor your delivery call to focus on your particular estate plan with your drafting attorney.
Yep, perfect. And then as just a disclosure, which this is already known, I just want to state that MCA does not give any legal or tax advice. That's why we have Brookhaven Legal in particular, represented by attorney Crystal Henry today, is the one that gives legal advice. Brookhaven CPA is the one that gives tax advice. So just as an FYI there, I think we can kickstart this, Crystal. The last thing I'll say, just as a guidance to you, the MCA client here, is obviously this is a long video. You don't have to try to watch this in one sitting or digest it in a single view. Most of the calls that happen with the attorneys are after MCA clients have at least watched the video once. That's required, but sometimes more than once. And you choose when you're ready to set up the call. So don't rush that. Don't arbitrarily delay it, but make sure you've watched this video before that call and you're comfortable with at least the concepts covered. If you need to rewatch it, go ahead and do so. We'd rather you come into this call well prepared so that it's a very efficient call, because you're going to get more out of it that way than coming unprepared and us having to spend the short amount of time that we'll have talking about things that are covered in this video. So just some guidance there. I think that's it, Crystal. Unless you've got anything else, I think we can jump into the documents. Does that sound good to you?
That sounds good to me.
Okay, let's do it.
So the first document I want to go over is the durable power of attorney. That should be the document that's reflected on your screen. As we stated, These are very generalized documents. We've got John Doe and Jane Doe names, very general names. It's going to be under Tennessee law. So again, don't get hung up on the aspect of the fact that it's Tennessee specific. Also, don't get hung up on the fact that the document you're looking at, depending on what state you live in, might look completely different from this document. It's going to contain all of the same provisions and it's going to accomplish the same basic goal. The things that we're going to go over on our delivery call, you and your attorney will go over on the delivery call, are going to be the differences that are more state specific for your documents. So let's talk about the power of attorney. The durable power of attorney is one of those core documents that every person should have as part of their estate plan. The durable power of attorney is what allows an agent, a person that you have appointed, to handle your legal and business affairs. It allows them to step in and handle your administrative affairs, your business affairs, in the event that you are incapacitated. So let's start with the first section. Something you will definitely see in your document is your name, obviously, stating that this is your power of attorney. And it will be appointing some type of agent. It might be appointing 2 agents. So in this document, we have Jane Doe as the initial agent. Some states refer to this as the primary agent. Some just refer to this as the agent. Some refer to this as first agent. So your document might say anything along those lines. Either way, this name here, this Jane Doe, will be the person that you've indicated to your attorney that you want to serve as your agent, as your power of attorney. Most documents, and your drafting attorney will discuss this with you, will require or ask for a successor agent. In this example here, we've appointed Bob Smith as the successor agent. This means that Bob will take over in the event that Jane is not able to serve. So let's say John is incapacitated and unable to make legal decisions on his own behalf. Jane can act as his power of attorney. She can execute documents. She can access accounts. She can handle real estate deals. There's a lot of power that goes into being the power of attorney. Jane can do that. If Jane is incapacitated or unable or unwilling to serve as the power of attorney or agent for John, then Bob will step into play. And those powers that were bestowed upon Jane will be transferred to Bob. This is something your attorney will go over with you prior to drafting. You will provide the name of your agent and your successor agent. If you don't choose to provide a successor agent, there will be nothing named here. There won't be anyone named. If some states require, if your state requires a successor agent, your attorney will circle back with you and say, we have to have this name. Please give us the name of someone to name as a successor agent. Any questions so far?
Yeah, I've got one question for you, Crystal. So just at a simplistic level, and I know this is for a John Doe here, a fictitious person. John becomes mentally incapacitated. He's in a car wreck. Jane Doe in this situation would be able to make, like you said, any financial or legal decisions on John's behalf. That's kind of the functionality. This is really applicable when something happens to whoever it is it's for, to where they can't make decisions on their own legally. Would you say that's a true statement?
Correct.
Okay.
Yep. So that actually segues us into the next section, which is going to talk about the powers that come with being a power of attorney. So the main thing that we're going to look for first is the names. Make sure that those names are correct of whoever's been appointed as your agent and successor agent. Then we're going to look into the powers of attorney. General power of attorney for the agent to perform all and every act, deed, matter, and thing whatsoever in and about your estate. That's a very broad statement. Obviously, it continues on, but it's important that you understand that this person, this agent, is going to be stepping in to handle all of your affairs in the event that you are incapacitated. Similar to an executor when you pass away. This person is going to handle anything that you would handle on a day-to-day basis and act essentially in your shoes. They will have access to your financial accounts. They will be able to demand and receive, meaning demand, sue for, and receive any and all debts, monies. So if there's a lawsuit that needs to be brought on your behalf, your agent will be able to do so. If you are sued and you are incapacitated, your agent will be able to act in your defense and hire an attorney to defend you in that situation. Borrowing, they may be able to borrow any type of loan as long as it is in your best interest. Credit cards, they may be able to use credit cards. Real property management, they may be able to lease, sell, and convey any type of real property that you may own, whether that's your personal home or an investment property. A power of attorney allows your agent to be able to to sell, lease, or otherwise transfer that property out of your name into someone else's name. They also can purchase real property. If it's necessary that your estate purchase some type of property, this allows your agent to do so. Investments. They may invest on your behalf. Purchase, sell, invest, reinvest, deal with stocks, bonds, etc. And this also includes hiring out any type of investment advisor or representative or professional to assist in this capacity. Securities, they can act in this behalf as well. If there's any type of security or property that is owned by you, they have access to all of that and may do so what they wish. Insurance, this allows them to access, purchase, maintain, switch, any type of insurance policies that you might have. They are able to cancel those, continue those, or pay premiums if you want to continue that one. That includes life insurance, liability insurance, hospital insurance, any type of vehicle insurance, should you have that, any type of health insurance. This allows them to access all of that. And as you can see, it continues on outlining the different powers that are appointed to the power of attorney to that agent. They can access bonds, they can purchase bonds, access safe deposit boxes, they can answer or commence in litigation, they can pledge, make charitable pledges. They can also employ people and professionals to assist in their serving as agent. So if they need the assistance of an attorney or an accountant or a financial advisor, this allows them to do so on your behalf. Next, this allows them to handle your taxes. It allows them to, again, hire any type of professional that they might choose to use, but also sign and execute in your name to handle any tax preparation or filings that might need to be done. This also allows them to apply for and obtain government benefits in your name and on your behalf. The catastrophic illness powers, this section allows your agent to access any type of benefits in the event that you have some type of catastrophic illness. beneficiary designations and survivorship interests. This is a little bit of a different, it's not so much a power, it more so is an instruction, but it says that your agent is able to designate anyone to be your beneficiary who under their power they think should be a beneficiary, as long as it's in your best interest and on your behalf. So keep in mind, while we're reciting all these different powers and going over all these different powers, keep in mind that your agent is always going to be acting on your behalf. They're always going to be acting in your best interest, not their own. Receive and redirect mail. They can receive, open, redirect, send mail on your behalf. Domicile. They can establish new residency wherever they may need to, and that would be on your behalf, changing the place where you are legally domiciled, where you are legally thought to reside. Supportive dependents. The agent may continue or initiate any type of support for any dependent that you might have already undertaken or that you might owe an obligation to undertake. Personal maintenance, this specifically pertains to you. Same thing with care agreements. This allows your agent to make sure that you're receiving proper care, maintenance, and any help that you might need while you are incapacitated, whether that be putting you into a retirement home or an assisted living home, contracting and selecting different physicians, surgeons, etc., and making sure that you are receiving proper care. Next, we have retirement plans. This section outlines what your agent is allowed to do regarding your retirement. This is more of a provision as opposed to a power, but there's no authority over life insurance on the agent. So the agent does not have any other power other than what's named here as far as your life insurance goes. So they're not going to automatically be a beneficiary or anything like that. This just allows them to purchase life insurance if you haven't already done so. It doesn't allow them to change the beneficiaries if it's not in your best interest and something that you already would want to do. There are restrictions on the authority. So the agent may not exercise any authority or power that's in their best interest as opposed to your best interest. Delegation, this just is a further restatement of allowing your agent to hire and delegate any type of task, any specific thing they might need help with during the course of them serving as your agent. Waiver of privileges, they are able to waive attorney-client privilege, physician-patient privilege, so that they're able to communicate with the professionals in your life that they need to communicate with. Reimbursement, compensation, they are entitled to reasonable expenses being reimbursed and reasonable compensation for serving as your agent. Commingling funds, they are not to commingle funds with their own funds. They're not to commingle your money and your estate with their own money. They may resign, your agent may resign at any time, but they have to give notice to you while you're competent. If you are not competent, then they must give notice to the conservator or guardian who has been appointed over you. If they themselves are the conservator or guardian, or there is no one serving, then they can give notice to the successor agent or to any person with whom you are residing or whoever is taking care of you at that time. And that's the order in which they would give the notice to. Reliance on photocopies. This is just some legal language saying that we don't have to have the original. We have to have the original, but we can rely on photocopies of the original, and you don't have to bring the original to every doctor's appointment of this power of attorney. You can bring copies of this powers of attorney. This is the IRS code that governs over anything that has to do with powers of attorney. And when we talk about the code anywhere herein, that's what we're referencing. So this is more of a definition. Yes, Blake.
Yeah, just a couple of comments and points as you wrap this up.
So, I mean, obviously, there's a lot that this is covering. And I think one of the themes that we'll see, Crystal, with all of the documents is they're really built to take care of these contingencies, some of which may be very unlikely. So there is a lot of verbose language, right? It's trying to capture many of the circumstances, which some may be unlikely, never occur. And some of these provisions don't really have relevance to the situation, but we can't predict the future. So we put certain things in there. You do as the lawyer. I'm not one to really cater towards those unlikely circumstances just to make sure we got them covered. Would you agree with that?
Yeah, absolutely. So it's not ever going to be perfect because we can't predict the future, like Blake said. The other thing that's important to note is keep in mind that your document might not contain all of this exact language. It might not be, it is probably, in fact, not in this order. Some of these might be Tennessee specific requirements. Some of whatever state you live in might require even more verbose language or even more information be provided within the power of attorney, or it might require less.
So, Crystal, it kind of all boils down to this is going to be built, obviously, based off of what the state requires. Probably some states are going to have more verbose language than others. But the point is, these type documents are trying to capture the situations into where someone would step into your shoes as it would call for if you were incapacitated. And then this is something, and Crystal, maybe speak a little bit to this if you can, that can be changed, right? Nothing here is locked in. Amendments can be made to this after it's signed. Can you speak a little bit to that?
So the biggest thing that you'll really be able to amend is who is your power of attorney. But Blake is right. It's not set in stone unless you were to become incapacitated tomorrow. So that's the biggest thing. If you become incapacitated, then this does get sort of locked up. But between now and that point, you can amend this and change your power of attorney at any time.
Perfect. I've got no other questions there, Crystal, if you got anything else or if we're ready to roll into the next section.
Yeah. So the power of attorney, ultimately, it's important to note that there's going to be different requirements as well as far as the signatures go. You're, of course, going to have to sign your power of attorney. The state of Tennessee does not require that the powers of attorney sign an acceptance, but some states do. So you and your attorney will go over the signatures during your delivery call, but it's important for you to make sure that you pay attention to those signature requirements. Does the person you're appointing as power of attorney or successor power of attorney, do they have to sign? At what point do they have to sign? Is it when you're signing or when they are accepting? So in the event that you're incapacitated, or in the event that you're incapacitated and your initial agent can't serve, then the successor would sign. So make sure that you and your attorney go over that. But otherwise, that's the main purpose of the power of attorney, is to make sure that somebody can step into your shoes and take over your affairs and your estate, your business, your legal matters, they can communicate with doctors, they can communicate with banks, attorneys, all on your behalf.
Perfect.
So
next is the healthcare directive. Is that right?
That's right. So the healthcare
Perfect.
directives, these are probably the most different for each state. The healthcare directives, some states require a separate healthcare directive appointment and living will. Some states just call it a living will. Some states just call it a healthcare directive. So it's all going to be, again, state specific, but because drafting for Tennessee for this sample video, it's Tennessee has the healthcare directive, and it's a combination of the appointment, meaning this is the person that I want making these medical decisions, and the directive, meaning these are my wishes in the event that I'm incapacitated and can't make these decisions for myself. So make sure that you and your attorney go over the difference between the living will, the healthcare directive, the healthcare appointment, whatever healthcare documents you are looking at. Make sure that you understand the differences. But ultimately, the healthcare documents, as we're going to refer to them, they serve two ultimate purposes. Number one is, who do we go to for my medical decisions? If you are incapacitated, unable to make decisions for yourself, who makes medical decisions for you? That's the first number one goal of your healthcare documents. The second goal of your healthcare documents is to outline what your wishes are. Some of the questions that you're going to want to make sure you discuss with your attorney are, number one, do you want to be an organ donor? Number two, how much life support, if any, would you want to be kept on in the event that you are in a vegetative state? And number three, who do you want making those decisions? So let's go over what this might look like under Tennessee. Like I said, some of the most important things, number one is going to be your name, saying this is my healthcare directive. The first and most important is going to be the agent who is making those decisions. There needs to be some kind of contact info in there as well, whether it's their address, their phone number. There has to be some kind of contact information for that agent in your healthcare directive. That's a requirement of all states, so make sure that that's in there. Some states require, most states prefer and suggest a successor agent. So talk about this with your attorney. Do you have to have one? If you don't have one, they might need you to appoint one. So just be thinking about that and then go over that with your attorney. But again, the successor agent or alternate agent is the person who would step in the event that your initial or primary or first named agent cannot serve as your medical agent. Again, this is all going to look very different, so I'm not going to go line by line, but this quality of life section is the equivalent of what you would see in your living will or healthcare directive, where it's asking about your wishes. Do you want life support? This is Tennessee's state required version. It's sort of a checkbox version where you say, I do want life support in these events. If I'm in a permanent unconscious condition or I have permanent confusion, end stage illnesses, and they have the client check a box saying this is the situation where I would want life support. Treatment, this is the same thing, a checkbox. What type of treatment would you want to be used in the event that you are not breathing? This is, some states refer to this as the DNR, do not resuscitate section. Do you want to sign this DNR? Do you want every attempt to resuscitate you to be made? Some states don't include this at all. So make sure you go over it with your attorney. They will go over this pretty in depth with you to make sure that you check all the correct boxes to accurately reflect your wishes. Here's more about life support, tube feeding, etc. And then again, the part that I had mentioned earlier that's going to be very important in most of these healthcare directives is your organ donor question. Do you want to be an organ donor? I want to say 99% of your healthcare directives are going to include that question. So make sure you have an answer for that as well. Any questions about the substance of what a healthcare directive is going to have?
I don't have any. I think that was a good overview. And like you said, Crystal, this is going to vary a lot state by state. And I'm assuming this is also something that could be changed at any point if John Doe decided he wanted to be an organ donor when previously he said he didn't want to. Mm-hmm. Is that a true statement?
Yes, it is a little trickier and a little harder to change because oftentimes when you have some type of healthcare directive or living will, it's very common to distribute that to your primary care doctor. If you have a cardiologist that you see regularly, or if there's a hospital that you see, it's common to provide copies of those. So I don't ever recommend drafting these with the intention of changing it, or really even using that as a safety net. I think this is something you should put a lot of consideration into, get your wishes down. You absolutely can change it. It's not carved in stone, but it is a little more cumbersome to go about changing and making sure that everyone has a correct copy of the most recent one if you change it.
Got it.
So there will be instructions no matter what type of directive you have saying what you need to do with this directive. Here you can see where I mentioned earlier, provide a copy to your physician, make sure you have a copy, make sure you get copies out to everyone who needs to have a copy. The appointment of healthcare agent might be something that the witnesses have to sign, or that the agent themselves has to sign. This is the physician order document. So this is something that would be provided to the physician. Some states require this, some don't. And this just again says what they would suggest in the event that you were incapacitated. It's something for them to keep in the chart. They go through and just check off the boxes. And then this is all the physician information, and the physician would have to sign it. And then this is a HIPAA disclosure form. Some states require this, some don't. In a lot of states, the the healthcare directive and the agent appointment itself, that would serve as acceptable for them to communicate without violating HIPAA. In Tennessee, they want an actual HIPAA disclosure signed as well. So you would have to sign this document and get a copy of this to your doctors, all of your healthcare providers, so that they have this HIPAA disclosure that they can talk to whoever your agent is. This is directions for the healthcare provider. Appointment of surrogate. This is something that would be kept in the hospital or doctor's offices, just in their files, saying it's essentially their version of a healthcare agent appointment, saying this is the person that you're allowed to speak to. And again, doctor would sign off, and an ethics committee in the event that there's any type of review that's required, or a second physician in that event as well. And then this is one that would require the actual appointment of, the actual signature of the appointed surrogate. So that's the extent of the Tennessee Healthcare Directive. Again, your documents might look very different from this. They might have a lot less, or they might have a lot more. If you are in a state that requires a living will, then you will have two separate documents to make up your healthcare directive. So just make sure you really go over that with your attorney and understand what all needs to be signed, by whom, and where do copies need to go. But just to wrap this one up, the main purpose, no matter what your documents look like, the main purpose of this healthcare directive is to make sure that we know who is making your decisions and what those decisions are, what those wishes and goals are. So next we can move on to the last will and testament. This is what we call a pour over will. You've received, or you will receive, a trust as well with your core estate documents. So far we've gone over the power of attorney, your healthcare documents. You're going to get a will and a trust. We call these wills a pour over will because it essentially points the court, in the event of your death, it points the court to the direction of your trust. It says, I've already outlined what I want to happen with my estate, so just make sure that you look at that trust. Everything is already in the trust. This doesn't need to go through heavy probate. We don't need an accounting of my assets. It names your executor and then directs everything to go to the trust. It also serves as a catch-all for anything that is not specifically disposed of within the trust. So let's get started as to what the general provisions will look like. This, again, I want to reiterate, is a Tennessee will, so your will might look different. However, this is going to be a bit more standardized. Your will should look fairly close to this one. There might be a couple different state-specific requirements, but unlike the power of attorney and the healthcare directive, it should look a lot more similar to this will that we're going over. So the main thing, number one, make sure it is your name on here. This is your will, and it's revoking any other wills. This is your current and most recent will. There's going to be a section about family information. It might look a little different, but there will be something that outlines who is my family. Who is my spouse? Who are my children? My grandchildren? Are there adopted children? Do we anticipate adopted children? There will be something along those lines outlining your family information. Next, there will be an executor section. Much like the power of attorney and the healthcare directive, the executor appointment is going to ask for a first executor and a successor executor. So the appointment of the executor, we've got Jane Doe here. There has to be contact information for that executor. And then preferably we're going to have the successor executor, Bob Smith. Has to be some contact information there as well. If you don't have a successor executor appointed, just talk about it with your attorney, see if your state requires a successor executor, and if so, make sure that you get someone added in there. Powers of appointment. This directs any and all power of appointment to your trust. So what that means is you're not taking any type of power that you would hold personally in your decision making and execution of your estate. You're not taking any of that power and bestowing it upon someone else through this will. The only appointment that you're making is the appointment of the executor in this will. Everything else is going to be in the trust. Some wills, I do want to note that the only other appointment that we will put in here will be a guardian appointment if you have minor children. Some wills require that, some states, require that that be done in the will. Any guardianship of minor children must be stated in the will. Some states are not, they don't require that it be in the will, so we might put it in the trust. Either way, something you want to double check and make sure that your attorney has included if you have minor children is a guardianship appointment somewhere in your estate plan, whether it's your will or your trust. You want to make sure that that's in there. And again, it's only if you have minor children. This is the pour over clause saying that any balance of your estate, anything that is not specifically disposed of either by this will or by the trust itself, just pours over into the trust. That's why we call it a pour over will. The next section is the administrative section. And again, your will might look differently, but all wills are going to include some kind of administrative language with a lot of legal jargon, a lot of stuff that is just state required that we have to include in there. It might be different from this. These are all the Tennessee state requirements. So I'm not going to go line by line or even section by section, but I want to make sure that you understand each article at the very least. So fiduciary provisions, that is something that will be included in every will. And this is saying who's going to be an accountant, who's going to be an attorney, who's going to handle all these different fiduciary positions. If the executor appointed by the will is not going to serve in any of those positions, there will be some kind of language, that's what all of this is, stating here's how you can appoint someone to those positions. Here's how you can hire an attorney, hire an accountant. Here is what you have to do to change that fiduciary. And there will be compensation provisions regarding the fiduciaries. There will be restrictions, any personal or state required restrictions as far as hiring a fiduciary. So let's say, for example, there's only one accountant that you want dealing with anything with your estate. You would name that person in this section and say that any type of amendment or change to that fiduciary position has to go through your executor, and both executors have to agree. Your executor and your successor executor have to agree. Whatever the provision is that you want to include, if you want to make it more difficult to fire that accountant. So that's just an example. Again, you don't have to include any of that. If you don't have any strong feelings about that, you don't have to put it in here. It can also be accounted for in the trust. So it might not be in the will, but it might be in the trust. Make sure you talk to your attorney and ask about that. General provisions regarding fiduciaries. Again, this is where I had mentioned there's going to be compensation requirements, reimbursement provisions. liability provisions, hold harmless provisions, state law versus federal law provisions, waiver of bond provisions, just sort of general provisions are going to be in there. Fiduciary powers, this is going to be in there as well. And this is what's going to outline your executor's powers. So whoever you've appointed as executor of the will, this is going to outline what it is that they are able to do in that position. So some examples, again, yours might look different, but distributions to minor beneficiaries, they can disperse things to minors or to a guardian. Power to sell, they can sell, convey, or lease real estate. Rely upon advice, they can rely upon the advice of any accountant, attorney, investment banker, or any other type of expert or professional that they've hired. And then executor as agent, this just states that they are acting as your agent and on your behalf, and they can serve as your agent. Similar to the power of attorney position, only the power of attorney document is only if you're incapacitated. This is if you've passed away. So there will be some kind of section in your will that essentially gives power of attorney, but really just them acting on your behalf. And then finally, in Tennessee, we've got our definition section, which just goes over what do we mean when we say estate or descendant or trust? What are we talking about in this document? Again, your document might have a lot more, it might have a lot less. The main provisions are what we've just gone over. There's going to be the fiduciary provision, which explains what your executor is allowed to do. There's going to be the appointment section, which is going to be appointing the executor and preferably the successor executor. There's going to be the family information section, which outlines who your family is, who are the beneficiaries, etc. And then there's going to be some kind of miscellaneous section, which is going to have all of the legal jargon in there that we have to put in there for state requirements. Any questions about the will?
I've got one, Crystal. So you mentioned earlier that it's a pour over will, which for all intents and purposes, as I understand it, means that whatever is in this bucket, if you want to call it that, is going to pour into the revocable living trust. Those assets will pour over, and that's really the main functionality of this will. When you talk about an executor, can you talk a little bit about what they're actually doing? Since everything's going to the RLT, the revocable living trust, what's the role of the executor from a practical standpoint as it pertains to executing upon this will at the passing of whoever it is the will's for?
Yeah, great question. So the executor is the person who's going to take the will and submit it to the court, give them notice that this person has passed away. Even though it's not going to go through the in-depth probate process, that's where we have the privacy aspect here. We don't have to submit inventory and accounting of your assets to the court and make that public record. We don't have to do any of that. We do have to still admit this will to court so that the court knows this person has died. Creditors can be alerted, etc. There's just certain legal requirements once a death certificate has been issued that this has to go to court in order for us to start making some transfers.
And had there not been, as you said, the revocable trust and that privacy aspect, then there would be a lot more generally requirements of the court as far as what's in the estate, who's it going to, all of that inventorying that you were talking about, which again puts beneficiaries of the will kind of under a spotlight from a public perspective, because it's all public information, generally speaking. So that is one of the benefits, is that revocable trust saying, hey, court, it's all dumping over here. That's a lot more private of a process.
Right, exactly. This keeps it from having to go through that lengthy court process and everything becoming public record, the beneficiaries, the assets, etc. But the other function of the executor is, so number one, to admit it to probate, and number two, to notify, in this instance, to notify the trustee. So if there's a revocable trust that is, I guess, the bucket that's catching the pour over from this pour over will, the executor has to notify the trustee that that trust has now become irrevocable and this person has passed away. So there's been a change in the dynamic, and they're going to have to start serving as trustee.
So it boils down really to notice, it sounds like. Notice to the court, local government, John Doe has passed away. Notice to John Doe's trustee for his revocable living trust, John Doe's passed away, and kind of handing that responsibility off.
Right, exactly. And just making sure that affairs are in order.
Yep. And then, I asked this question with the previous documents. Amendability of a will, very easy to amend as I understand it, and could be amended as many times as technically someone would want to amend their will. Of course, we don't advocate it's over amended. I wouldn't think that would be a good idea, but it's important that this be kept up to date, relevant, and nothing is truly being locked in today. Like you said earlier with, I think it was the healthcare directive, nothing's really locked in until incapacitation occurs. And then, you're really not changing anything after that, obviously. Anything I said there that's incorrect?
Right. That's true. Yes. Once you're incapacitated, you're not able to make any other changes. Everything gets locked in. But until that point, you absolutely can amend your documents. Like you said, we don't advocate that it's done just all the time. It gets hard to keep up with what was the most recent document. There's a lot more room for contest of the document and ambiguities as to which one is the correct version. It just creates a little bit of confusion, but definitely it's definitely amendable if something changes. The reason to amend that I always say is any type of big life-changing event. If you get divorced, or if you get married, if you have another child, not necessarily even if you have another child, unless you just want their name specifically written in the will. We draft our wills to make sure that it accounts for you to have children and for you to have grandchildren, so that you don't have to amend it every time you have a child or a grandchild. But if you want to, that's a life-changing event. You absolutely can amend just to add their name in there. But we draft to where you don't have to do that. Now, let's say you want to disinherit one of those children. That's going to be a significant event that we need to come in and amend your will for. So things like that, that's the kind of stuff you amend, not just typically not, I would not recommend just because you've thought about it some more and you changed your mind and you want something different now. I'd say really make sure you think through your wishes beforehand so that we're not amending over and over again. So the no contest clause is going to be in every will regardless of the state. The no contest clause is something that says anyone who comes in to contest your will has to do so in good faith, or they'll be disinherited from the will. Or even if they do so in good faith and they lose, they can still be disinherited from the will. This is something that will be default drafted into your will regardless of the state that you're in. So make sure that if you don't want something like that in your will, you let your attorney know. It's standard practice. We typically recommend that you keep it in there because it does prevent a lot of frivolous contests of the will just because someone's unhappy with their position in the will. Or if you don't really see it being an issue, it doesn't hurt to have it in there. But if it's something that you feel strongly about wanting taken out, let your attorney know. That's the no contest clause. It's a bit long. And then the savings clause, this is something else that's important to go over. It does say that anything that might be found to be invalid in this will does not invalidate the whole will. It just invalidates that section. Something else that's important to note, regardless of the state that you're in, you're going to have to sign this in front of witnesses and a notary. So make sure that you don't fill anything out without getting in front of a notary, and make sure that you go with disinterested witnesses. Disinterested witnesses are friends, family who are not beneficiaries, or employees at the office where you're going to sign. So I recommend going to, and if you have a local attorney that you know, or if you have a bank that you use and have a good relationship with, they will often have paralegals or other professionals at their office who are willing to sign as witnesses. They are totally disinterested parties. There's no way they'll ever be a beneficiary of the will. So they are considered a disinterested witness. Most wills require a minimum of one disinterested witness. A lot of states require two. So make sure that you check with your attorney as to how many you need, and they'll tell you, and then you make sure that you get those people to go with you when you sign. There's going to be some other little attachments with your wills. Self-proving affidavit is a very common one that you will see. Tennessee requires it, and a lot of other states do as well. Just saying, I am me, and then the witness saying, yep, John is John. And that also needs to be notarized. Now let's move on to the trust. So the trust is going to be named with your initials, your and your spouse's initials if it's a joint trust. If it's a single living trust, then it will be just your initials. The trust is upwards from, it's 60 pages, so we're definitely not going to go line by line through this. It might feel like I'm moving a little fast through it, but there are some important things that I want to touch on when going over the trust. So first, we're going to make sure that we have our names here. John Doe and Jane Doe are the trustors. Trustor is whoever is creating the trust. Whoever is the trust is created for the benefit of. Whoever's assets we are dealing with in creating this trust. Trustee is going to start in the revocable trust as John and Jane as well. So whoever is the trustor is also the trustee. This gives John and Jane complete access and control over the assets of the trust. It puts everything into a nice organized fashion being in this revocable trust, but it doesn't take away their access and control like some of the other trust structures do. The next important part that I want to talk about is transferring property to this trust. Transferring property to this trust is done by the Schedule A form. I'm going to scroll really fast here to the bottom. Whoop, maybe. There we go. So the Schedule A is the last page of your trust, and it looks like this. $10 cash is just a requirement. You don't actually even have to put the $10 in there. It's something just to create the trust that we have to put there. As you start funding the trust, think of this as like a table of contents of what is included in your trust. Just because you write something here, let's say you want to put your personal home into the trust. Just because you write that address here does not mean that it's in the trust. It means you intend it to be in the trust. You still have to do the process of retitling that house into the trust. You have to go through that separate process. Same thing with bank accounts. Just because you write bank account information here does not mean that the assets in that bank account are actually in this trust. You have to actually transfer it over. So this is very helpful in that it points your trustee in the direction of knowing what is supposed to be in this trust, but it doesn't have any legal effect. So I suggest transferring the assets first. Transfer the property, transfer the bank accounts, do the actual required steps with the bank and the title companies and et cetera to get all of your assets funded into the trust. And as you do that, then you write them on this Schedule A. I would not suggest writing anything on this Schedule A before you've actually gone about transferring it into the trust. Any questions about that?
Yeah, I've got one comment. Really, it's something I see time and again is folks will pay to have an estate plan put together, to have a revocable trust drafted, and they'll usually get to the point where they sign it. But where the ball's dropped is with exactly what we're talking about: funding the trust, retitling property, making sure that the right things are in the right buckets, everything you were saying, Crystal. So it's a really important takeaway, I think, from this and from the meeting that you'll have with your drafting attorney, is that signing these documents doesn't mean the work's done. Like Crystal said, we got to make sure that the right things are retitled and that this Schedule A is updated to reflect that in the appropriate and legal manner, so that when you pass away, everything's treated in the manner that you want it to be treated with.
Absolutely. Yeah, the trust is essentially an empty wallet if you don't actually put stuff into it. I'm scrolling fast back up here. Where were we? Okay, so Like I said, that's that first page there, the transferring property into the trust is not done by putting it on the Schedule A, but an inventory of what you have transferred can be seen in the Schedule A as long as you update it. That can be handwritten. I always ask my clients that as they update their Schedule A, as they transfer things in and jot things down, just send me a copy of that so that I, as the drafting attorney, have the most up-to-date version of that Schedule A. Your drafting attorney will probably say the same thing. Just make sure that you keep everybody up to date that you think might need to know that you've added something into that trust. Make sure you keep everyone up to date with the most recent version of your document. So this section further talks about the powers reserved by the trustors. The trustors are the people creating the trust. So in this case, John and Jane Doe. And this section just says that they are maintaining power over their assets because they are acting as the trustees. And either way, even if they weren't acting as the trustees, they are reserving those powers as trustor. Article 2 is family information. Your drafting attorney is going to have you double check names and dates of birth to make sure those are correct. This accounts for children and grandchildren, even if they're not named here. So if John and Jane have more kids, even after this trust is created, those kids are not kept out of the trust. They're just not alive at the time of drafting. But the trust will account for that and make sure that they and the any descendants thereof will be included in this trust. This next section is very important. It talks about trustee succession. So this talks about what happens after the trustees pass away. So while the trustees while the trustors are alive, they can remove and replace the trustee as they see fit. They can make that change by amending the trust. Once they are incapacitated, there's no more. The successor trustee becomes whoever is named as successor trustee. So in this case, the way that we've drafted these documents is to make sure that our clients have the Tennessee trust protection. So you have to have a Tennessee or a trustee who's located in Tennessee. I myself am located in Tennessee. So for John and Jane, we've drafted with me to serve as the trustee. So when John and Jane pass away, I will step in and serve as trustee. Blake, you have a question?
Yeah, and you kind of answered it right there at the end. But the reality here is that the trustors, John and Jane, they maintain control until the second of them becomes incapacitated. I was just going to highlight that. In this case, Crystal, as the named successor trustee, would not step in until the second of those two individuals, John and Jane, are incapacitated. So there's not a premature handoff unless, and I've heard you talk about this before, Crystal, they wanted that handoff to occur prior to the second incapacitation. That's always an option too, right?
Absolutely. So in the event that John passes away and Jane doesn't want to serve as trustee by herself, that is how it would naturally flow, unless Jane contacted me and said, hey, I want you to step in and serve as successor trustee for John alongside me and help me administer this trust.
Yep. And like you said earlier, in one of the sections, John and Jane maintain control over the trustees, who that is, I mean. And if they wanted to replace you in this case or anyone else named at any point, no one can stop them from doing that. It's just a simple amendment of this trust document away from naming whoever it is that would fill that role. Is that a true statement?
Yes. So if you wanted to change your successor trustee, you can absolutely do so. While you are incapacitated, while you are capacitated, both trustors have to agree and sign off. That's a common question that I get is if I want to change the trustor or the successor trustee once my spouse is incapacitated, can I do so? The answer is no, you can't. They have to sign off on that. So any changes you want to make to that, I would suggest doing so, immediately if you're able, decide you want to. And then this gets into a little bit of a later section, but it's another reason why I suggest appointing a trust protector. because appointing a trust protector allows them to assist with any type of reassignment, hiring and firing of trustees in the event that one or both of you are incapacitated or deceased.
And I think you said it there, incapacitated or deceased. I've seen a lot of folks equate incapacitation to solely deceased, and they don't think about it in terms of, well, maybe you got in a car wreck and you're incapacitated mentally. Maybe you're, God forbid, on a ventilator in a hospital. This still accounts for that situation to where if you're still alive, but maybe not mentally capable of making legal decisions, the trustee would step in as though you had almost passed away for purposes of their role. They're still going to be serving John and Jane if they're mentally incapacitated and making sure that things are done for their benefit, but it would still trigger that role and execution of the trustee is really what I was getting at. Any disagreement or comment there, Crystal?
Well, no. I want to make clear. So if one of the trustors is incapacitated, that does not trigger the trustee to step in. That triggers the power of attorney to come into play,
Right.
the healthcare directive to come into play. The trustee, successor trustee would not step in that event. It would just fall to the one other trustor who is still fully in their capacity. If both, let's say, God forbid, both of them get into a car accident, both trustors are incapacitated in a vegetative state, that's when a successor trustee would step into place.
Yep.
And
Got it.
on their behalf. I think that's, is that what you were saying?
No, it's not, but that's good clarity. So in this case, both would have to be incapacitated or have passed away for you in this situation to step in the role of successor trustee, unless whoever the second person was said, hey, I don't want to do this, and they ask you to do it while they're still alive.
Exactly. Yep.
Okay, perfect. Thank you for that clarity.
Yeah. Then trustee succession after death is a lot cleaner. Once both trustors have passed away, the successor trustee would step in. So it's similar in the sense that both have to be passed away. So if one of the trustors pass away, so let's say John passes away, Jane would serve solely as trustee, unless she says, hey, Crystal, I want you to step in and start serving as trustee on John's behalf. I don't want to deal with his half of the estate. Or maybe I can't deal with his half of the estate. There's many reasons as to why that might come into play. But either way, the successor trustee does not spring until both have passed away. Removal and replacement of trustees. Again, this is something that the trustors are allowed to do while they are alive and fully capacitated. In the event that both trustors have passed away, then the trust protector can remove or replace a trustee. And in the event that there is no trust protector appointed, or they are not able or willing to serve, then the beneficiaries can move to have a new trustee appointed. So any unfilled vacancy, if there's no person appointing in that role, there's no trust protector serving to appoint someone, then that's when courts typically will have to get involved. And that is going to, again, come from the beneficiaries filing something with the court, saying, hey, we need to have a trust protector or a new trustee appointed, and the court will appoint someone to serve in that role. So these are just some further trustee provisions that the trustee can appoint a co-trustee if they need assistance with a specific aspect of the trust. Let's say it's a very business-heavy trust, so we need a more business-savvy trustee. Your trustee can move or can hire and bring on a co-trustee to serve alongside them and handle those specific provisions and aspects of this trust. In the event of any kind of incapacity of the trustee, they can appoint a co-trustee if it's done before they're incapacitated, or the trustors can appoint someone new. If they've passed away, then the trust protector can appoint someone new, or worst case scenario, the court would have to get involved to appoint someone new to that position. Everything must be documented and everyone must receive notice. Prohibited trustees, this says that beneficiaries who are minors or subject to a supplemental needs trust or a special needs trust cannot serve as trustee of this trust. So we talked about how we transfer the role of trustee and who is going to be administrating in the event of trustor incapacity. This section goes over the rules for distributions. So this is the guidelines section that tells whoever is serving as trustee, this is how you serve as trustee in the event that one of the trustors or both of the trustors are incapacitated. Same thing here, only for the trustors passing. So we know who the trustee is going to be in the event that both trustors pass away. This is the guideline that says, how do you serve as trustee of this trust once they've passed away? This section is the disposition of tangible personal property. This is what allows the trust, even if there's personal property that hasn't been named and specifically placed into this trust, the trustee can distribute it fairly and equitably amongst the beneficiaries. That's not something that's typically going to be held in trust unless it's specifically titled into the trust or specifically put into the trust. But let's say jewelry, household items, art, just tangible personal property of the trustors. This is what allows the trustee to chop that up amongst the beneficiaries. If there's anything specific, that brings me back to this, if there's anything specific that you would want to go to your beneficiaries, let's say you want all your jewelry to go to child 1, you want your art collection to go to child 2, that's something that you need to have discussed with your drafting attorney. They might put that in the will, or they might put it here in the trust. When I'm drafting personally, I like to put that in the will. I think it's just cleaner. It disposes with that personal property before it even makes it to the trust. So I like to put that in the will. If there's an extensive amount of it, we might put it in the trust, but really it just depends, and it's going to be a drafting preference of your drafting attorney. This Article 7 is sort of a directional article, so I'm not going to explain it. I'm going to explain the next articles that it's talking about. It's sort of a, if this is the situation, go to Article 8. If this is the situation, go to Article 9. So I'm going to go over the articles and you'll see what I mean. So Article 8 is the marital trust. So in the event that one of the trustors has passed away, this marital trust is created. The trust sort of splits into two buckets. Article 8, and we'll get to it in a minute, Article 9. The marital trust and the family trust. So Article 7, the one we were just looking at, directs us that if one of the trustors has passed away and there's a specific piece of property or a specific asset that the spouse has no interest in and wants to waive their inheritance interest in, it will bypass bucket number 1, the marital trust. I'm going to scroll fast here, and it will go into bucket number 2, the family trust, to be divided up amongst the rest of the beneficiaries. So the marital trust is where all of the assets will go once trustor number 1 passes away. This allows that spouse, the surviving spouse, to operate out of the trust as if it's still just the one trust, which it's important to note here, it is technically still just the one trust. These are just little sub buckets that are temporarily creative, and they are more administrative than anything. It's for the successor trustees and the current surviving trustor to keep things clean and separate. So everything will automatically go to the marital trust unless the surviving trustor says, I have no interest in that property, send it straight to the family trust for the beneficiaries. This allows it to stay separate. Once the surviving spouse passes away, the descendants trust is created, and the family trust and the marital trust, so Articles 8 and 9, essentially go away. Everything that was left in the marital trust when spouse number 2 passes away, and everything that was in the family trust when when trustor number 2 passes away, all funnels back into Article 10, the descendants trust, which brings it back to one trust. So we start with our marital trust or our joint trust. One passes away. So with these 2 temporary buckets develop, once the second passes away, it all comes back to one trust. What we've done in the meantime with the marital trust and the family trust is keep the assets separate for an organizational and administration from that standpoint. So we know X amount of dollars has already been distributed to the children. X amount of dollars was being lived upon by spouse number 2. It allows us to administer the trust cleanly while one surviving spouse is still alive. So once everything gets back into this descendants trust, that's when the trust truly comes into play, if you will. This is when we actually start seeing those protections. Both of the trustors have passed away. The trustee is now 100% stepped in, serving in their trustee capacity, and they are distributing out the money out of this trust to the beneficiaries in accordance with what the trustor's wishes were. So the way that we naturally draft is per stirpes division of the property, which means equal amongst the beneficiaries. If this is something that you want to change, if there's someone that you are disinheriting, or if there's just a different method that you, or a different division of shares that you want to employ, make sure you've discussed this with your drafting attorney so they know that they need to draft disinheriting language, etc. Otherwise, this gives us our standard right here. I'm going to highlight it: health, education, maintenance, and support. So once the trustors have passed away and the trustee has stepped in to start dispersing the property, the health, education, maintenance, and support, or HEMS, H-E-M-S standard for short, is what is the industry standard for trustees to use to determine whether or not a distribution is going to be approved or denied. It's a very broad definition. We can fit almost anything up under that definition: health, education, maintenance, and support. So if there's any specific distribution requirements or distribution timeframes that you want to add, make sure you discuss those with your drafting attorney. This is where those will be reflected, stating how those are supposed to be distributed, etc. But otherwise, this is going to be the default go-to: health, education, maintenance, or support. As long as a distribution request falls under one of those 4 categories, it should be approved. The only other thing that the trustee is balancing when deciding should I approve this request is there enough money in the trust? Is it going to deplete the trust to approve this request? Otherwise, it's that HEMS HEMS standard. So this section here is where we would put any exclusion language or disinheritance language. If there's anyone who would be a beneficiary, so a child or a grandchild, someone who would naturally be a beneficiary that we don't want to take from this trust and we want to disinherit, this is where that language will be. So if you've discussed that with your attorney, they'll go over this section with you as to how that's laid out. Article 12, very broad, but it specifically deals with underage or incapacitated beneficiaries. So if when both trustors pass away, if any of their beneficiaries are underage or incapacitated, this says what we do with that. Do we have to create a supplemental needs trust for the incapacitated beneficiary? How do we distribute the money if the child is underage? Does it go to their guardian? Does it go into a separate account? That's what this is going to say. The way that we default to drafting, so when I say that is unless you've told your drafting attorney otherwise, the way that it defaults is the trustee can distribute for underage beneficiaries, they can distribute to the guardian or whoever is appointed the custody and care and control of that child. So if the guardian or caregiver, whoever it is that is has custody of that child, if they make a request for a distribution, the trustee can distribute to them on behalf of the child. And then same thing with, for incapacitated beneficiaries, a supplemental needs trust can be created to make sure that the main focus of distributions is on these things listed here. So it gets a little bit more specific and provides a little bit of a stricter standard as to what can be approved for an incapacitated beneficiary if they're making a request or their guardian is making a request. Any questions about that?
No.
All right, so it's a little lengthy there, this section. This is all, again, about underage and incapacitated beneficiaries. It talks about how we can distribute, record keeping, things like that. Article 13, trust administration and trustee powers. So this is the section that outlines what power the trustee has. It says we want minimal court supervision. We don't want to have to go to the court every single time that a request is made. And it gives the trustee the power to weigh that HEMS standard against the balance of the trust and say, is this an appropriate distribution? Can the trust afford to make this distribution? And then ultimately make their decision to either make, approve, or deny that distribution. This explains that the trustee can only act on behalf of the trust, not in their own self-interest. It explains that they are entitled to reasonable compensation for their services as trustee. It explains that there has to be a valuation determining the principal and income of the trust. So the beneficiaries have to be kept aware of the value of the trust and the balance of the principal and the income and how that's determined. It also provides the trustee with the authority to merge, sever, or terminate trusts. So in the event that, eventually the trust will run out of money. One day, hopefully it's way, way down the road, but it will. And once it becomes no longer feasible to continue administering this trust, this gives the trustee who is serving at that time the authority to terminate the trust. So, for example, if the trustee's annual fee is going to all but drain the trust, it doesn't make sense to continue with that trust. So they're able to terminate the trust, distribute whatever whatever assets are left to the beneficiaries, and wrap up the serving of trustee and terminate the trust. This section, the specific powers of the trustee, it's pretty lengthy. It starts with letter A and I believe goes to double C. So this outlines the specific powers of the trustee. These are not changeable, really. They're statutory and it's standard for a trustee. If there's any of these, I'm going to scroll so you can see just kind of the length of the powers here of the trustee that you feel very strongly that you don't want your trustee to have power over. Talk to your drafting attorney, see what they say. But I'll tell you, chances are they're not going to take it out. It is mostly statutory, and most of it, if not actually all of it, in my opinion, is necessary for the trustee to have power, these specific powers, in order for them to serve effectively in the position. But if there's any that are really just a true red flag for you that you want to discuss with your drafting attorney, just make sure you bring it up to them and they'll see what they can do about maybe revising some of the language or something. And then limitation on trustee power. This is standard kind of boilerplate saying that they're not able to deal in self-interest. They're not able to take out life insurance policies for themselves, that kind of thing. So the next section is Article 14. This goes over 2 more fiduciary positions that will be added into the trust. The first is the investment advisor, and the second is the trust protector. So make sure you talk to your drafting attorney as to who might represent you in these positions named in your trust. So first, the investment advisor is the fiduciary individual or entity who's going to be handling the investments of this trust. I can say as an attorney trustee, you don't want me deciding how to invest the assets in your trust. That's not my wheelhouse. I don't know how to judge those markets and numbers. That is something that you want a professional financial advisor who does that every day handling. Someone that I, as the trustee, would work hand in hand with and say, here's how much money we have in the trust, how much they're, low risk or high risk. You worked with them. How much should they invest? That kind of thing. So we would still have a communicative relationship and a co-working relationship, but they would be the one to make that decision. Any questions about that?
Yeah, just one comment. I think it's one of the benefits of the way your team drafts these trust crystals, because I've seen a lot of situations in where the trustee is the decision maker with regard to investments. And it's not always a great situation because a lot of times you're right, the trustee doesn't have that experience, but now they have their hands in every aspect of the trust. What's good about kind of separating these two roles is that you've got someone, the lawyer, you in this case of this document, serving as the trustee over the whole enterprise of this structure. And then you've got a subject matter expert, someone like you said, that's an investment advisor, that's just another fiduciary looking out, providing very specific advice pertaining to how the investments are maintained within the trust. So I think it adds another fiduciary, it's another set of eyes, and it helps spread the workload out. And again, I think that's a good way to do this. I've seen trusts that try to cram it all into one person's role, and that can be a bit much and not necessarily the best when it comes to trying to ask one person to do everything, right?
Right. That's exactly right. And it just keeps that subject matter in the areas with the experts of that subject matter. So in this case, for John Doe, we've drafted Bison Advisors as the investment advisor. That would be whoever is your investment advisor that you work with now. Make sure that you contact them and clear that with them. There's a couple more nuances in serving as an investment advisor to a trust as opposed to just you, the client. So you want to make sure that you discuss that with your investment advisor, make sure they're willing to serve in that type of position, and let your drafting attorney know. So that's the position of investment advisor, where they're going to be handling the investments and making the assets in your trusts grow. The next position that I want to talk about is the trust protector provision. This is another fiduciary provision, and this is something that I really suggest having is a trust protector. So the trust protector is a person who's going to serve after the trustors have passed away as sort of a voice for the trustors. The trust protector has some pretty broad powers. They're able to hire and fire trustees. That's a good thing for multiple reasons. Number one, if the trustee is not serving and distributing and approving and denying requests in the way that this trust protector knows the trustors would have wanted them to, the trust protector can fire them and appoint a new one. The other reason that it's good that they can hire and fire trustees is because if something happens to the trustee and they're not able to serve, it's a very clean avenue to know, who do we go to appoint a new trustee? The answer is the trust protector. So the trust protector would appoint a new trustee without a hitch. We don't have to have any court involvement. We don't have beneficiaries fighting over who's going to be a good trustee. It takes some of the pressure off of the beneficiaries and tries to keep this out of the court. Any questions about that?
Yeah, just real quick. I mean, it's another set of eyes, right? It's someone to safeguard the trust, especially like you said, after the trustors are no longer here. A lot of times it's someone that the trustors are close to, from what I've seen. Someone they trust, someone that understands, like you said, the rule book, kind of the spirit of the trustor's intent. And it's someone that has some pretty far-reaching capabilities to remove and replace certain decision makers, really no questions asked. I agree. I mean, I just in practicality from my point of view, which is not the lawyer on the call, but having seen these trusts administered, it is something that is a good safeguard at the end of the day. If you can have the right person in there now, and that's someone that can be replaced, obviously, Crystal, right? You know, the trustors, if they want to change who that is, they could do that. Very similar to changing the trustee, the successor trustee. Can you speak just a little bit to that?
Yes, while the trustors are alive, they can remove and replace the trust protector. Otherwise, they're not really changeable or replaceable. That's it. The trustee can't remove or replace a trust protector. That might defeat the purpose of the trust protector. No, it's something that is really only done by the trustors. In the event that both of them pass away, the primary beneficiary can remove the trust protector, but it's not recommended that be something that they do. It does create a little bit of a if there's multiple children, for example, and the primary beneficiary is the oldest, they replace the trust protector because they're not getting their way with some of the disbursements that the trustee is making and the trust protector is agreeing with. It creates some ambiguity there. So it's something that I don't recommend doing, removing trust protectors. I'd say if you have someone that you trust enough to put in that position, a family member or maybe even a friend, but someone who's not a beneficiary, I would suggest doing so and leaving it at that.
Yeah, it can create, to your point, some conflicts of interest there if you have multiple people kind of wearing multiple hats that they shouldn't, beneficiaries being trust protectors. I've seen that too. And just for clarity, you know, the way that you and your team draft these trusts is the trust protector really doesn't step into this role until the second of the trustors, or I should say all of them, both in this case, have become incapacitated or passed away. Is that a true statement?
That's correct. Yeah. None of these positions, this trust really doesn't come into play, if you think about it, until both of the trustors have passed away. Trust protector is not serving. Investment advisor is not serving. Even that trustee is not serving until both trustors are either incapacitated or both passed away.
Now, the investment advisor could serve, right, to where if they set up an account and, you know, it was just managed under the name of the trust. But by and large, you're saying, hey, Blake, there's, you know, most of these positions are really there for when the decision makers are no longer around to make decisions. And, you know, that makes sense. We're proactively planning here. The other piece of it, I mean, is this required? You have to have a trust protector? Because a lot of folks that I've spoken to, and I've been on calls with you, they're like, I don't know who I want there, and maybe not anyone right now. Maybe I'll add it later. Is that okay? Can they add a trust protector later? What's your thoughts there?
Absolutely, they can. And it's not required. They don't have to add one ever. It is just a super helpful position. So I always advocate really strongly that they have one. But at the same time, because it's such a helpful position, it's a very hard to appoint position, because the reason it's so helpful is because it's so broad. It really provides a lot of powers to this person, this trust protector, in the sense that they can hire and fire trustees. So they can hire and fire the person who's going to be administering the trust. The outline of the trust protector provision, powers are in section 14.7. I'd recommend, it's pretty long. I'm going to scroll fast so you can just see. I'd recommend reading through at length. Yeah. Oh, no, that's still, hold on. There we go.
It's kind of like the trustee powers, right? It's addressing a lot of situations, some of which might not even be applicable, but giving them that far-reaching latitude just in case it's needed.
And it's done on purpose. So it's not something that I, as your drafting attorney, or you might talk to your drafting attorney about it, but I will not change the powers of the trust protector. It's a statutory position. So a lot of this stuff, even if we take it out, is a power that they will likely have anyway, just by law of the position. It's a very broad position on purpose. This person is essentially stepping into the shoes of the trustors to make sure that this trust is running according to what the trustors' wishes would have been, to make sure that the trustee is doing their job and serving in accordance with what the trustors would have wanted. So it's a very, very important position. Think very hard on who you might trust enough to put in this position. But to short answer your question, Blake, you don't have to put anyone in this position. That is one of the things that my clients commonly say is, I just don't know who I trust enough. I don't know who to put there. And that's very normal, very common, and it's okay. We can leave that position blank. You can appoint someone later, or you can appoint someone never. In the event, I had mentioned this earlier in the call, if you don't have a trust protector appointed, the kind of handoff there is there might be some more court involvement in the event that successor trustees are not lined up, in the event successor investment advisors are not lined up, et cetera. That it's really more of those contingent situations that could arise that there's no way for us to really account for. You can't account for everything. That's where trust protectors really come in handy. But not having one does require us to go to the court for appointment of positions like that. That's really the only main drawback to not having one. Otherwise, there's not really any drawback to not having one.
Got it. Okay. Well, that answers all my questions on the trust protector side of this. Thanks.
Okay. So that essentially wraps up the trust protector section. The rest of it just goes over, just like the investment advisor, that they have the right to access records, employ professionals as needed. They're entitled to compensation, both the investment advisor and the trust protector, et cetera. So all just kind of the nuanced legal jargon that has to be in there explaining the role and the powers of those positions. So make sure you get with your drafting attorney and think on who you might want to put in that position. And if you have any questions about that, make sure you talk to your drafting attorney. The final article, Article 15, the general provisions, this is sort of that miscellaneous catch-all. If you recall earlier, I had said there is a provision in this trust that says the trustee has to think about the person that's requesting the distribution. Are they a spendthrift? Do they just spend money frivolously? Here's that provision saying that they have to think about that. Contest provision, this is similar to the will's no contest clause, that if you contest this trust, you risk being disinherited. This is all just kind of the law statute, or the statutory language, stating that this is a Tennessee trust, stating anti-lapse statutes. It's all of the boilerplate stuff that has to be included in a trust. Definitions, what do we mean when we say adopted? What do we mean by good faith, descendants, etc.? This is all still definitions that we're scrolling through. Per stirpes, shall, my, trust property. What do we mean by all of that? General provisions, multiples, plurals, governing state laws, Tennessee. Notices have to be written, and then severability, that every section is taken in and of itself. If one piece is found to be invalid, it doesn't invalidate the whole trust. Boilerplate legal stuff. So that is the final article. Any questions about the trust overall? Because now we're just getting into the, I'll do signatures real quick. That's it, the signature pages. So any questions about the trust?
No, I think you do the signature pages and I'll kind of wrap up and then we'll be good to go. I don't have any other comments or questions.
Okay, well, that's it with the signature pages. They've got to be done in front of a notary. This doesn't have a place for witnesses. The trust doesn't require witnesses in Tennessee. If you bring witnesses and you want them to sign the trust, just have them sign somewhere down here and put that they're a witness, but it's not necessary. The requirements for witnesses, that's going to be in your wills, your powers of attorney, your healthcare directives. Otherwise, just make sure you go in front of a notary before you sign and date anything. Don't write anything anywhere unless you're in front of that notary, because you'll be printing new documents to sign, new fresh documents. But that's it. That is our core estate documents. Brief recap. We had the power of attorney, which is what gives your agent the right to access and handle your affairs, legal affairs, business affairs. We have the healthcare directive, which again will look very different depending on what state you live in. It might be a living will, might be an appointment, a healthcare appointment, might just be healthcare directive. Main goals of healthcare directive is who is my agent and what are my wishes from a medical standpoint. Third, we have the pour over will, the last will and testament. And then fourth, we have the trust. So those are the 4 documents that we went over. Make sure you get with your drafting attorney if you have any specific questions, but these are the basics that your document should reflect.
Operating agreement. Is this the end of it? I can't remember if there was a page after this or not.
It is, but that's it for the operating agreement. Your drafting attorney will go over any other specifics or questions that you have. So make sure that you've compiled your questions to go over with your drafting attorney.
Perfect. Okay, we'll transition now to the next item on the board. Thanks, Kristen. So just a break there, and we'll have them cut that out.
Cut.
Yeah, cut. I've got a call at 11. I'm going to stay on, but I'm probably just going to not share my face. So I'm probably not going to have much commentary for the Asset Protection Trust, but I don't think I need to, because I think you would agree after having reviewed it, the material difference between this and the revocable trust is really only in its irrevocability by and large. A lot of the provisions are similar when you look at the revocable trust and what will happen after it becomes irrevocable.
Yeah.
So that, just for the sake of time, because I think we've got stacked on 2 hours in the prior video, or right at, and we're at 51 here. So I don't know. I guess what I was just going to get at before I jumped was realize you've already gone through maybe a good bit of content that's possibly redundant with the revocable trust, to the degree that maybe you don't have to dig as deep in certain parts here. That's all I was going to say, rather than treating this as like what it feels like is we're just going to start from scratch and move forward because we haven't talked about anything about this today. But they have seen stuff that kind of overlaps with it. So I don't know the balance there, but I think if you've got a goal from a timing standpoint, I don't know if this is realistic. 30 minutes might be really good. Probably going to have like 20 minutes with the CRT. So that's going to be, I know not this whole video.
Hour.
Yeah, another hour. So we're looking at maybe an hour 45 after you cut out some of just the small talk in this video. So 2 hour 45 minute videos. So that's 4 hours. What is that?
I think so. 2 and 2 is 4.
Oh,
45.
So 3.5, but that's a long time.
Long video.
I think Melanie's and Glenn's was about 2:20.
Okay.
So it's not that much longer, and this is a little bit more detailed. I don't think it's bad. I think they're still going to watch it. But I think we're kind of edging up on we definitely don't want to hit 4 hours. I think that'd be a
I
but
agree.
anyway, that's all I was going to say. I'll stay on screen just for a second. And then as we get closer to 11, I won't be there for commentary. That's the big thing I wanted you to know.
Okay, gotcha. And then can you see me while my screen is shared? Am I small, or does it look just the screen? That's it.
I can see the screen and you off to the side.
Okay, cool.
Here,
So
I'll
it looks like.
Here's what it looks. Let me see.
Do I need to stop sharing?
I think I can just take it. Okay, that's how it looks when you're sharing. Do you see me on the side?
Oh yeah, you're down, just little. We're little.
Yep.
Okay.
Yeah. So that's exactly how it looks for me. All I can see is my screen, obviously, but I'll stop sharing. So yeah, I can see you the whole time. I'll be down there, but I'm just gonna do one of these.
Yeah, that makes sense. But that's good. What I want to do is probably put this asset protection trust right after the revocable trust.
Okay.
I think, in the order of the video.
You think that? Yeah, I don't. Yeah, I think so.
What do you think?
I think that's fine.
Okay.
Perfect. Yeah. So you go ahead and start that. I'm going to go ahead and pull off. Someone's at my door right now. I'm going to go answer that. And then once you're done, I'll probably be done with my call right around the same time. But if not, you can just hop out and I'll end it.
Okay, got it.
Okay, perfect. See ya.
All right, so next we're going to talk about the irrevocable trust. We've already spoken in this video and gone through the revocable trust. That is the trust where you serve as the trustee, you maintain control of the assets. There is the privacy and the probate avoidance benefit of the revocable trust. The irrevocable trust is more restrictive. The irrevocable trust, you cannot serve as trustee. You cannot change the terms of this trust. You cannot withdraw this trust or dissolve this trust. And it locks the assets up essentially to where you cannot freely move them in and out because you are not serving as trustee. So what it essentially does is it takes the assets that are put into this trust and removes ownership from you individually. The Asset Protection Trust requires that a Tennessee qualified trustee serve in the position of trustee. So if you want to access the funds, if you want to receive a disbursement or maybe sell something out of there, you have to contact your trustee. And the trustee has to approve that disbursement or deny that disbursement, depending on what it is, the purpose of it, and the trust balance, the amount. So let's get into the irrevocable trust. A lot of the terms you're going to notice with this irrevocable trust are going to be very similar to the revocable trust. That's because trusts in general, whether it's an irrevocable family trust or a revocable family trust, are seeking to accomplish similar things. So a lot of it we've already gone over, so I'm not going to go very in depth with because we've already kind of talked about it. What I want to focus on, just for the sake of time, what I want to focus on is the differences between the irrevocable trust and the revocable trust. So like I mentioned a minute ago, one of the biggest examples, or one of the biggest differences, is that the trustee cannot be you. So John Doe and Jane Doe serve as trustors, or they are the trustors, they created the trust, and they also serve as trustee of the revocable trust. The irrevocable trust, however, they are the trustors because they're creating the trust, but in their trust, I'm serving as trustee because I'm a Tennessee qualified licensed trustee. So a qualified trustee in Tennessee is either a trust company or a Tennessee estate and trust attorney like myself. So that's the first requirement. And it's the first difference, I should say. Identifying the trust, same thing as the revocable trust. It's any type of titling and retitling. When you go to do that, when you go to move your assets and title them into the trust, you want to make sure that you are properly titling them. It will be into just the name of the trust or the name of the trustee as trustee of the trust. Reliance by third parties. They can rely, any third party can rely on the terms of this trust. Here's one of the other big differences from the revocable trust to this irrevocable trust. An irrevocable trust is exactly that, irrevocable. It cannot be altered, amended, revoked, or terminated. Once this exists, it exists, period. It cannot be thrown away, terminated, anything like that. It exists in perpetuity and cannot be amended. So it's set in stone, in other words. That's very important for you to understand and know. Transferring property to the trust is just like transferring property to the revocable trust. Just because you list it on the document at the end here does not mean that it actually is in the trust. You have to go about the actual retitling process. So if it's a bank account that you want to be owned by this trust, you have to go to that bank and tell them, hey, I want to move this bank account to be owned by my irrevocable trust. What do I need to do? Every institution is different and has different requirements. That's why it's not really something we as Brookhaven can help a whole lot with. We can provide you guidance as to what type of assets you need to be thinking about retitling into the trust, and maybe who you could contact to do that. Maybe do you need to talk to a title attorney? Do you need to talk to the bank itself? Do you need to talk to your investment advisor? Who do you need to talk to in order to make that happen? That's the extent of what we will be able to do for you there, because every institution is different. So please make sure that you actually go through the process of moving assets into the trust, especially this trust. And the reason I say that is because the irrevocable trusts, like I said, are not revocable. Once they exist, they exist. And you have a trustee that you are paying an annual fee each year to serve and monitor this trust. So if you set up this trust and put nothing in it, you are paying a trustee fee for minimal monitoring and reason and purpose. So it's very important and makes the most sense for you and is in your best interest to get your properties titled into this trust as you see fit. Of course, you don't have to put everything in here. Don't rush to put things in here, but make sure that you get things funded into the trust. Otherwise, it's just an empty shell. So, transferring property to the trust, once you go about actually doing so, make sure you keep track of them on your Schedule B document. That's the document that's at the end of this trust. And we've talked about it before with the other trust. It serves as sort of a table of contents or a reference document indicating this is what you should expect to see in this trust, but it doesn't have any actual legal effect. The rest of this is all going to look very similar to the revocable trust. So I'm not going to go in depth over some of these clauses because they are mirrored to the revocable trust. Grantor trust protections. Power to add a charity as a beneficiary. If you want to add a charity as a beneficiary, that is one type of amendment that is allowed. If you want to designate a charity to become an additional beneficiary of the trust. This is the same, Article 2, the family information. This is the same as the revocable trust, indicating who is who. Trustee succession provisions. This is important. If the trustee resigns, they must do so by giving written notice to the trustors. If the trustors are incapacitated or deceased, they must do so by giving written notice to the trust protector. If there is no trust protector, then the trustee must do so by giving notice to the beneficiaries. So either way, if a trustee must stop serving as trustee for any reason or is incapable of serving as trustee, they must give notice to somebody depending on the situation, letting the individuals who are privy, letting them know that this trustee is no longer serving as trustee. We don't have a trustee succession listed out here unless when we're drafting your trust, if you happen to know of another Tennessee trustee that you want to include in here, either to serve from the get-go or to serve after myself. So we don't have any designated trustee. It's a matter of the trust protector or the beneficiaries. In the event that the trustee is no longer able to serve, they would have to find someone to serve in that position. And it would have to be a Tennessee trustee. Again, all notices will be given to either the beneficiaries or the trustors or the trust protector, whoever's alive, incapacitated, and serving at that time. The rest of this is all the same as the revocable trust. Article 4 covers the investment advisor. The investment advisor is, again, the same as the revocable trust. That investment advisor position needs to be designated. We've got Bison Advisors listed here. That's who we work with as Brookhaven. Designation of an investment advisor is, who do you want to be the financial advisor in charge of making sure that the money and the assets in this trust don't stay stagnant. They are invested properly and they grow properly. So you appoint a financial or investment advisor, just like in the revocable trust. All of this is the exact same provisions. Next is tax advisor, same thing as the revocable trust. Who do you want to handle the accounting of your trust? So you want to name someone. We've named Brookhaven Tax because obviously that's who we work with. Brookhaven Tax handles the accounting for the trust, any IRS filings, to make sure that it all kind of stays in-house. I think that's the cleanest way to do it. That is what I advise and recommend, of course. All of these terms are the same as the revocable trust. Next is the trust protector. Again, same as the revocable trust. The trust protector's position is a very powerful position. There's a lot of trust that needs to be, that ends up being given to this person by the trustors. So it needs to be someone that you're very comfortable with serving in this position. So John and Jane have appointed Bob Smith. Maybe he's a cousin, maybe he's a sibling, maybe he's a very good friend, someone who's going to serve in the position representing your interests, monitoring the trustee to ensure that the trustee is following and abiding by the rules of the trust and the language of the trust as it's laid out. They have the power to hire and fire trustees. They have the power to appoint new trustees. There's a lot of trust and responsibility placed on this person. So the hardest thing is determining who would we want to put in that position. That's the hardest thing that our clients struggle with. I think we talked about this with the revocable trust. If you can't think of anyone that you would want to put in this position, that's okay. We don't have to have this position filled. We can just leave it blank. So you can circle back. This is one position that you can appoint at a later time if you choose to do so, or just not have anyone serve in this position at all. That's okay as well. Either way, all of the terms for the trust protector are the same as the revocable trust. The position is for them to monitor and serve in the position of acting in the trustor's best interests and representing the trustor's wishes and desires to the trustee and making sure that the trustee is adhering to the terms of the trust. Article 6 covers administration of trust property. This is very similar to the irrevocable trust as well. We have the same HEMS standard, health, education, maintenance, and support for distributions. So the difference here is that it starts immediately, whereas with the revocable trust, the trustors are serving as the trustees. So they can distribute assets out of the trust kind of however they want because they're maintaining control. Once the trustors pass away and the successor trustee steps in to serve for the revocable trust, that's when that HEMS standard comes into play. So people will be requesting, beneficiaries will be requesting distributions, and the trustee will say, does this fall under health, education, maintenance, or support? Do the trust assets allow for this amount of distribution? Is this person a spendthrift? They make those considerations and then either approve or deny the distribution. This is exactly that same process, only it's immediate. The trustors are still alive and the assets are tied up, and the trustee has to make that determination and make that distribution or either approve or deny the distribution based on that HEMS standard. So there is the request that's involved from the trustors as well. Otherwise, the rest of this is the same as the revocable trust. It functions the same as the revocable trust functions when the trustors have passed away. This functions that same way. Remote contingent distribution, we talked about in the revocable trust as well. This is if we end up cutting anyone out that would otherwise be a beneficiary and we don't want them to. So that's where we would include that information. Distributions to underage and incapacitated beneficiaries, Article 8, same rules as the revocable trust. It says that we can distribute to a guardian or a parent if the person is underage or incapacitated. If we need to set up some type of bucket of a supplemental needs trust, we can do so in the event that there is an incapacitated beneficiary or an underage beneficiary. In the supplemental needs bucket, we would value and make sure that we are highly valuing medical, dental, education, insurance, essential needs over maybe more frivolous needs. The objective is still to promote independence of the beneficiary. We are allowed to distribute to someone other than the beneficiary themselves because as a minor, for example, or an incapacitated beneficiary, we would need to distribute to the guardians. So the rest of this is all the same and functions the same as underage and incapacitated beneficiary terms in the revocable trust. If you have specific questions about this, make sure you speak with your drafting attorney. But otherwise, it is exactly the same. Trust administration, again, same thing. Distributions to beneficiaries the distributions need to go to the beneficiary themselves. Trust decanting. So this is a little different. If we need to decant this trust, this is the provision that allows us to do so. Decanting the trust means moving all of the assets from one trust to another. So if for some reason this trust needs to be resitused in another state, or we need to dissolve this trust and move it into another trust way later on down the road, this is a pretty cumbersome process and a pretty expensive process. So I don't want you to think of it as sort of a backup or a fail-safe to this being irrevocable, because it's not. It's only for specific reasons why a trust would be decanted into another type of trust. And there's certain requirements that have to be met in order for that to be allowed for us to even do. If it is allowed for us to do based on the state law and the requirements and things like that, if the situation occurs and we determine it is the best course of action is to decant the trust into a different trust, there has to be some language in the original trust that says you can do that if you need to. So this is that language. No court proceedings, no bond, standard language, just like in the revocable trust. We want to keep this out of court as much as possible. We don't want court involvement with needing to approve every distribution or every change. We don't want to have to involve the court as much as possible. We want it to be decisions made internally. Trustee compensation, employment of professionals. These are all exactly the same as the revocable trust, the same terms. They can employ professionals if they need to. They can be compensated a reasonable amount. Accounting, determining the principal versus the income. All of that is the same as the revocable trust. All of this is the same. It is standard kind of boilerplate language. Funeral expenses, generation skipping transfer tax provisions. This is in the revocable trust as well. Article 10 covers trustee powers. These are the same as the revocable trust for when the trustee takes over with the revocable trust. Trustee powers are to designate the power to invest to the investment advisor. Same thing, delegate the power of accounting and tax preparation and tax work to a tax advisor. But otherwise, in general, the trustee has the power to approve or deny investments, to approve or deny any type of banking relationship or banking decision, business decision, contract decision, standard investment decision. This is specific to the digital assets. The trustee has the authority to access, modify, control, archive, transfer, and delete digital assets. So this includes emails, digital music, digital files, web accounts, things like that. Anything that the trustee needs to be able to access, they can have access to. Now, because of the nature of MCA and crypto, I know a lot of your assets are true digital assets. This does not give the trustee authority to just delete all of your crypto or do whatever they want with it. That is not what this is saying. The LLC operating agreement covers that. The LLC operating agreement covers or provides that the individuals are the members. So John and Jane Doe, they are the managing members. They have the authority to make those decisions as far as the assets go, those digital addresses and crypto assets. They have that authority. The assets, the actual digital crypto assets, are owned by the LLC. The trustee does not own the assets outright. So the trustee does not have authority to just do what they wish with the digital assets. The LLC owns those assets. What this section provides is that the trustee, in their position as trustee, has the authority to access the information, to discuss the information, to request copies of emails and things like that. So this is actually a standard kind of boilerplate term, if you will. But I know because of the nature of the crypto assets, it could be a little bit confusing. So I wanted to make sure that I commented on this. So this does not give them any additional power or abilities to make decisions as far as your crypto goes. That remains in the control of the manager of the LLC, which is you, the individual. So this is continuing on through the trustee powers. Some of these will not apply at all. Environmental powers, farming powers, insurance powers. If there's any type of insurance that needs to be purchased through the trust, the trustee is able to do so. They are also able to employ insurance agents to make sure that they are finding the most appropriate plan and deal, if you will. So yeah, all of these are the same as the revocable trust. Oil, gas, mineral interests. A lot of these will probably not apply to you unless you own this type of asset. And we want to make sure that if there is required language, it's in here. So that's why this is fairly lengthy. Payment of property taxes. They're able to pay taxes out of the trust as needed. Purchase assets. They're able to purchase assets. They are given real estate powers if they need to sell or convey or purchase any type of real estate within the trust. So all of these are the same as the revocable trust. They are standard powers of the trustee. We keep the powers pretty broad because that is what gives the true separation of the trustee having ownership and full true control over the assets. We want to make sure that we're able to make a straight-faced argument defending that these assets are not owned by the individual. That's what gives this asset protection. Limitations on trustee power. Obviously, their power is not absolute. So this outlines the limitations on those powers. And keep in mind that even though we just went through a long list or scrolled through a long list of broad, extensive powers of the trustee, their number one fiduciary duty is to act in the best interest of the trust and you as the clients, the trustors. So they're not, while it feels a little intimidating to say, oh yeah, we're turning over power and ownership and control of all of our assets and giving this person kind of unfettered control over it. That's not 100% the case. And even if we do consider that to be 100% the case, they have to act in your best interest. So they're not going to be just selling property for no reason or, dissolving assets, things like that. That's a breach of their fiduciary duty. They're not allowed to do that. They can be held liable for that. So everything that a trustee does is going to be in the best interest of the trust, the assets in the trust, and the trustors who created the trust. Next, we have just the general provisions. Again, every document has those sort of outliers that don't really fit under any of the other sections. So that's this one. The spendthrift provision is just like the revocable trust, that one of the considerations that a trustee has to consider is when someone makes a request for a distribution, they look at the HEMS standard, health, education, maintenance, and support. Does it fall in that category? And then they also look at the amount of assets that are in the trust. Is this going to significantly deplete it? And then they also look at, is this person a spendthrift? Is this person constantly asking for large sums of money that they're going to deplete this trust very fast? And it's not in the best interest of the trust, and it doesn't align with what the trustors wanted for this trust. They wanted this trust to last for generations to come. And this beneficiary is wanting to just spend through it. That's what's known as a spendthrift. So this is what allows trustees to say no for spendthrift as the reason. Contest provision, standard language saying that the trust is not to be contested. If somebody contests the terms of the trust, they can be cut out of the trust. The definition section, just like in all other legal documents we've gone over, we've got these definitions where we've thrown terms around throughout the course of this document. Excluded person, good faith, incapacity. What does that mean? How do we determine that? What is the definition of that term used throughout this document? So that's all these. And then same thing, the general provision section is the same as the revocable trust, saying that the governing state law is Tennessee. Notices need to be provided via mail. Severability, if one section is found invalid, it doesn't invalidate the whole document. Finally, we have our signature pages. Each trustor must sign and have notarized. There's Jane Doe. She's got to have signed and notarized. And then this one is important. The trustee has to sign. So for most of you guys, I believe a Brookhaven attorney like myself is going to be serving as trustee. If not, and you're going with another Tennessee trust company or trust attorney or whatever you're doing, they have to sign this document. They have to accept the appointment as trustee. So it's another reason we recommend just keeping it with us, because the drafting attorneys, it's kind of a standard practice that the person who drafts your trust will serve as trustee if they are able to do so for this reason. It makes things a lot cleaner. But anyway, either way, make sure that your trustee signs the trust document. Something that is specific to the irrevocable trust, not the revocable trust, is this qualified affidavit. This is an affidavit that has to be signed by the trustors that essentially say, I am who I say I am. I have the right and ownership rights to all of the assets that we're transferring into this trust. I have the right to own them, control them, retitle them, transfer them. I am legally allowed to do that. So that's what this affidavit says. Both trustors have to sign. And this is specific to the irrevocable trust. And then finally, we've got the Schedule B. This is referenced earlier in the document, and it's also the same as the, I think it's Schedule A in the revocable trust, but here it's Schedule B. The same thing, where this is sort of seen as a table of contents / reference document as to what assets should be expected to be seen in this trust. Please remember, I can't stress it enough, you have to go through and actually do the work to retitle the assets. It is a lengthy process. It is a cumbersome process, but it has to be done. Otherwise, the trust is an empty trust. Writing something on the Schedule B does not have any legal effect in transferring assets. This is just a table of contents to summarize what you have transferred into the trust so the trustee knows what to look out for. So that's it for the irrevocable trust. If you have any specific terms, this is very common actually, that you might have some specific terms as to how you want things to be distributed to your beneficiaries. Maybe you want it laid out or divided up a certain way amongst your beneficiaries. Maybe you want certain age distributions. Those specific terms are what your drafting attorney is going to go over with you. They are going to have them, highlighted to make sure that you guys definitely touch on them. Your drafting attorney will know to discuss those because they are deviations from what we've gone over in this standard document. So make sure you go over those with your attorney. You might have already noticed them if you have your documents pulled up and you're scrolling along. But otherwise, hopefully you guys have written down some questions for the irrevocable trust and any other documents in this video. And make sure that you go over them with your drafting attorney as well. All right, next let's talk about the operating agreement. So this is a sample operating agreement of what your crypto LLC will look like. All of our LLCs are going to be set up in Tennessee. So that's why this is a Tennessee limited liability company. The operating agreement is for a company we've made up called Entrusted. So you'll see that referenced throughout here. So let's get into the information and the terms. The operating agreement is sort of the guidelines and the handbook as to how your LLC is set up and expected to operate and run. There are some specific terms in here that are very crypto focused and crypto related because of the nature of the business. So we'll talk about those as well. So the operating agreement is for Entrusted LLC. As stated, that's the name of the company. This is always going to be blank upon delivery because you're going to fill in this date when you sign it. This is going to be blank as well until after the articles of organization have been filed. That is something that we will take care of on our end, but we want to wait and add the date in here once the articles of organization have been filed. So your drafting attorney will tell you what date to include in here, or when they do the revisions, they might go through and do this as well. There's a couple things that depend on that, such as registering with the Tennessee Northwest registered agent. All things that your drafting attorney will go over with you in specifics and provide instructions for. So if you see these two blank lines, they will be blank on delivery as well. This one you'll fill out with the date when you actually sign and execute the document. The purpose of this document is to create the LLC and lay out the terms, conditions, and expected operation of the company. Formation and name, it's formed by us filing the articles of organization. Like I said, we will take care of that for you, and we will either enter this date or let you know what date to put here. Principal place of business and registered office and registered agent. You'll notice that these both have the address of the Tennessee Northwest registered agent located at 116 Agnes Road in Knoxville, Tennessee. This is a registered agent company. You don't have to use this company, but this is the company that we recommend and suggest. We do require that you have a corporate registered agent. This is because if an individual is serving as registered agent and then withdraws or resigns, it creates a lot of issues and can eventually lead to the dissolution of your company if the appropriate steps are not taken. So the only exception to this is if you individually want to serve as registered agent and list your personal address. Most of our clients we've found don't want to do that because it does remove a bit of the anonymity. Your name will be linked to the company through the Secretary of State. Your name will be what's listed where any type of service of papers gets mailed and sent. So this allows you to have the anonymity, but also removes the risk of having a random individual serve as registered agent. So the only exception to this rule is if you are personally serving as your own registered agent. The drawback of having the registered agent service is there is a cost. Your drafting attorney will have that information for you. This is something that you will need to register for prior to us obtaining certain IRS and Secretary of State documents. Once you register for this service, one of the great things about them is they will handle your annual compliance documents, filings, things with the Secretary of State, even things with FinCEN requirements, which ask your drafting attorney if you have questions about that, but it's a federal government compliance requirement. So they will handle this for you. I believe you can opt out of those services if you want just the minimal mailing address registered agent service, but I always recommend you go ahead and opt in just to make your life easier, to make sure that everything is in compliance, make sure that deadlines are met, unless it's something that you're comfortable handling on your own. So if you have any questions about the registered agent and getting signed up for that and the cost of that and the specifics of it, make sure you talk to your drafting attorney. They know to go over it with you anyway.
Just Crystal, real quick, the purpose of a registered agent, I know a lot of folks, that's probably a new term for them. How would you define what they do? I know you listed some of the stuff they do, but why they exist and kind of what they're standing by to do from a legal standpoint, if you don't mind.
Absolutely. So a registered office and registered agent is, in the most 50-foot high view explanation, it's where you receive your mail and where you receive service of process in the event that there's any kind of legal action pending or being filed against you and your company. The registered agent is the point of contact for the LLC. The registered agent services, this is what they do for a living. They obtain mail, they obtain information, and then they forward that information to the individual that they have listed internally. So, for example, John Doe, one of the members of this example LLC, he will go in and register with Tennessee Northwest Registered Agent. And any mail that is sent to his LLC, which is Entrusted LLC, any mail will go to that address. Any service of process will go to that address. This Knoxville address is what will be listed with the Tennessee Secretary of State. So if someone needs to look up the address for Entrusted LLC, this is what will show up.
And Crystal, I mean, obviously they could have, mail go where they want for just regular day-to-day stuff. But what you're saying, if I understand correctly, is that if there's any formal type mail that has to do with some legal proceeding or state communication or something that's really official, it's going to here, and the state requires that this be in their system because they want to know that if they need to get in touch with this business, that there is a very clear way that they can do that. Is there anything that I said there that's not correct or that you wanted to add to?
No, that's exactly right. When you register with the state, the requirement is that you have a registered agent address. And the only requirements about that address is that it has to be a physical address. So the options are either your individual address in your home, or your personal place of business, or a registered agent service.
Now, if they're outside of Tennessee, can they have their home as a physical address as a registered agent, or is that option only for folks inside of Tennessee?
That option is only for folks inside of Tennessee.
Gotcha.
We can have the principal place of business be the home address. The Secretary of State doesn't require that they match. The principal place of business just says where business is going to be conducted out of, but because it's a Tennessee LLC, we list the same registered agent address because we are allowed to do so, and it preserves that anonymity. A lot of our clients value the ability to use the principal place of business as the registered agent address as well.
So the bottom line is if they're outside the borders of Tennessee, they have to have a registered agent. There's going to be some cost there. The good thing is that that registered agent will do things administratively that the MCA client won't have to worry about, like certain filings and such. But really, more than anything, it's a formality that the state requires for us to document and register, so that if there's any formal communication, they know where to send it. That all makes sense. I appreciate you going through that.
Yep, absolutely. And that's exactly right. And of course, the registered agent will forward mail to you. That is part of their position as well, is receiving the information and receiving service and receiving the mail, preserving that anonymity, but then alerting the proper people that they have on file. So they will let you know, hey, you received service of these records or service of this litigation matter or whatever the thing may be.
Perfect.
So moving forward, let's talk about the members of the LLC. The members are going to be outlined in Exhibit A of this document. That is further down at the end. So we'll go over that and we'll circle back to this, but it's going to explain who all is a member of this LLC and their ownership percentages. So what we can do, I'm going to scroll fast. Here we go. This is the Exhibit A membership roster. So as you can see, this outlines who is a member in this LLC. It's the irrevocable trust, the revocable trust, and then the individuals themselves, John Doe and Jane Doe. And then it shows their ownership percentages. So this explains, and this Exhibit A is incorporated through the section that I just showed you up top in the operating agreement. As you can see, the irrevocable trust is a majority owner. The ownership percentage of 97% is with the irrevocable asset protection trust. However, the revocable trust and then the two individuals own 1% each. We will talk a little bit later about how the management of the company works. So don't think that just because the irrevocable trust is the majority owner, don't think that that means that the irrevocable trust is in control, because that's not the case.
Yep. And while you're scrolling back up, just to comment on that, the whole reason why 97% or really just a vast majority is in that irrevocable trust is because it's the most protective structure of what's being set up. So putting things inside of the bucket with the thickest firewall is really just protective posturing. The other minority interests are more about making sure there's access by you personally or through your revocable trust, which you control. But yeah, thanks for going through that, Crystal.
Yep, and Blake's exactly right. So the members of the LLC, this outlines the voting rights, limits the liability. It's got just kind of the boilerplate standard language. The way that these LLCs are structured are internal to where it's going to be you or you and your spouse and your trusts. So there's not really a lot of outside members or external from the family members that we need to worry about as far as meetings and adding members, things like that. If that's something that you do wish to do at a future date, make sure you discuss that with your attorney so we can talk about the best way of going about that. Next, let's talk about management. So I mentioned when we were looking at the Schedule A that just because the Asset Protection Trust is the 97% owner does not mean that they are in control of the company. The manager is in control of the company. So in this example, John Doe is one of the individuals. He is the manager. He is in charge of day-to-day operations. He does not have to consult with either of the trusts or with Jane Doe, for that matter. He doesn't have to consult with anyone to conduct his day-to-day operations. If you wanted to have John and Jane Doe share the duties as manager to where they do have to work together, we can set that up as well. I'll explain how that affects certain other terms here in a minute. But the manager is going to be an individual. It's not going to be the revocable trust, And it's definitely not going to be the asset protection trust where the outside trustee is serving. So manager is always going to be the individuals, meaning you or you and your spouse, serving and controlling in that position. So you maintain, which this brings us to section 3.2, you maintain exclusive authority and exclusive control and decision-making power when it comes to selling, exchanging, liquidating, doing anything with your digital currency assets and with any of the company assets for that matter. You maintain control of the crypto and all that is contained within this LLC. Unanimous member decisions. This would require approval of all members. So that would include both John and Jane Doe. And it would also include them serving in the position of trustee for their irrevocable trust and the outside trustee serving for the irrevocable trust. So this is if you want to make any changes to this LLC document, add any new members, hire any new employees, things like that, selling the business and dissolving the business, making charitable contributions. These are things that you want to consult with the trustee about anyway to make sure that the assets are appropriately lined up with whatever decision you're wanting to make when it comes to maybe a charitable contribution or selling the business. These are things you would want to have involvement with your trustee anyway. So next, let's talk about distributions. Operating distributions and liquidation distribution. This essentially just says that the managers, so John Doe or John and Jane Doe, can make distributions from the company as they see fit. They can put money in, they can take money out. Next, we have contingencies. This is in the event that, so for example, we named John Doe as the manager of this LLC. This is in the event that John either passes away or becomes incapacitated. What do we do? This says that the other managers will step in and that the LLC should continue to operate in accordance with whatever is laid out in this agreement. The successor manager that would step into his position would be Jane Doe. Now, if we had drafted it to where John and Jane Doe are simultaneous managers, up a couple sections to where they are serving at the same time, then Jane would not be a quote unquote successor manager. What we would do is just remove this successor manager section altogether. You don't want to name an outside individual to serve as successor manager because the manager needs to be a member. The manager who's making the decisions and controlling the assets needs to be someone who has an ownership interest in the company. So in this situation, John and Jane are not serving consecutively and jointly as member managers. John is the only manager. So Jane is the successor in the event something happens to John. In the event something happens to John and Jane has already passed away, there would not be any successor manager. In the event they were serving together, then whichever predeceases the other would be the successor, or well, actually, whichever does not predecease the other would be the successor manager. So if they're serving together, John passes away, Jane would take over. If they're serving together and Jane passes away, John would take over.
So, Crystal, I've seen a lot of folks kind of get bent around the axle trying to figure out who that person would be, especially if they're single, and trying to just think through that possibility and all the different permutations of what could happen and who do I want in that role. And a lot of times it just never gets true traction because it's a bit of trying to predict the future and what that relationship would be like at that point in time. Nothing's stopping this from just not having a designated successor manager, correct? In that event, the members would nominate someone, to my understanding.
Right. Well, if it's not someone who's already a member, we're not going to name anyone else. This isn't like a trust protector position or some other positions that we'll discuss in this video. This is strictly someone who is a member of the company, which the members are only going to be John and Jane Doe, the clients. So it's either going to be John and Jane serving together, or in this situation, if John is serving and handling all of the crypto and handling all of the decision making and something happens to him, then Jane would step in. But we wouldn't name an outside individual. We wouldn't name anyone here unless it's themselves.
So if there was no Jane Doe or something happened to both of them at the same time, what would that situation look like?
We would not include this successor manager. And what would happen is the trustee, if something happened to them at the same time, or if there was no Jane Doe, the trustee of the Asset Protection Trust would essentially make the decision based on what the clients had indicated in their other estate documents. Do we want to dissolve this LLC? Did they leave the LLC to their children? So we need to draft a new operating agreement and do some transfers to where the children are now the managers of the LLC. Do we need to set up a new LLC for the children? There's a couple different options there, but it comes out of the operating agreement at that point. If it's not member specific, John and Jane Doe, then it's decisions that are going to be made outside of the LLC.
Got it. So the point I think that could be made is that there's some built-in redundancy there, even in the worst of situations, or if there's not a successor manager that's ever named. That makes sense. I appreciate you going through that.
Yeah, definitely. And so this only comes into play, of course, if the managers pass away or are incapacitated. Next, this is some boilerplate stuff about transferring, restricting on transferring of units. We are not, no person can transfer any units without consent of all members. So what that means is they can't sell their units of ownership to some other person or transfer in any way for that matter, even if they're not sold. We're not inviting other individuals or entities for that matter to come and become members of this LLC without the consent of all members. That includes the trusts and the trustees. Right of first refusal: if someone passes away, then the other members have the right to buy up those shares, the ownership interests, before it goes to outside companies and outside entities. This is, like I said, pretty standard kind of boilerplate language that is included in here. It's probably not going to arise or apply because just the nature of the way this LLC is set up. It's important that we have it in here for any kind of contingencies, but it's probably not going to come into play because the way this is set up is with either just you yourself as a single individual or just you and your spouse. So it's not going to come into play unless we start bringing in other individuals at a later date. Next, we're going to talk about capital units. So the way that this is divided up is 10,000 units. You all probably saw on the Schedule A the different units of ownership. 97% of them are in the irrevocable trust's name, and then 1% for the revocable trust, and then each individual, totaling the 100% of the 10,000 units. There's no capital contributions required to open this. That means that we don't have to put any money in as members in order for this to be opened. This is a different bit of information than the trusts, for example. There are certain things that there's certain funds that have to be deposited in order to open bank accounts and get trustee services going. This is different from that. This is just saying that in order to create this LLC, you don't have to deposit funds anywhere for this LLC to operate on. A lot of LLCs do require that, so we have to make it clear that we do not require that. This is tax language explaining how the capital accounts are going to be viewed and taxed. And then finally, next we're going to talk about dissolution of the company and winding up of the company. So if you want to close the LLC, if you no longer want to have it operational, you can dissolve the company. You can do this either by written consent of all members, written consent of all managers, or the entry of a decree of dissolution by a court. So it's not incredibly complicated to dissolve and wind up an LLC. The biggest complication, if you will, is going to be the assets in the LLC that are owned by the LLC. Once something is owned by the LLC, if we want to dissolve and close this LLC for any reason, everything has to be sold out of the LLC. It has to be transferred out of the LLC. There cannot be any assets left over as being owned by the LLC. Something else that's important is administrative dissolution. It's not talked about here in the operating agreement because it's not something that you really put in an operating agreement. It's just an important legal function that you guys need to understand. If you do not make sure that you do all of your annual compliance requirements, make sure you do all of your Secretary of State filings, you can be administratively dissolved. Your LLC can be administratively dissolved, meaning the Secretary of State will say that the company is no longer in existence because certain documents were not filed each year. These are documents that we will initiate for you, but we do not keep up with them each year. That's not something that's included in the Brookhaven scope of work. So that is another reason why I highly recommend using a registered agent service, because they will handle that for you to ensure that your company is not administratively dissolved. They will make sure that compliance is met and all requirements are satisfied so that your company maintains good standing with the Secretary of State. For tax and accounting purposes, it's characterized as a partnership. It's still a limited liability company, but just for tax purposes, not further purposes. You would still be an LLC, but for tax purposes, it is classified as a partnership. The indemnification clause, this is essentially what makes a limited liability. It allows individuals who are members, managers, or any type of agent of the company, it indemnifies them from being held liable for acts of the LLC performed within the scope of the LLC's business. Of course, there are exceptions and piercing the corporate veil. There's reasons that attorneys like me have jobs, and it is exactly this. If something happens, then there's always an attempt to pierce the corporate veil to try to find a way to hold an individual liable if they can. But the fact that it's an LLC does provide those protections and requires any attorney in any litigation event. It requires them to take those extra steps and prove those required elements that piercing the corporate veil would be appropriate. So in the event that you're involved in any type of litigation with your LLC, you want to make sure you contact an attorney who's going to be able to handle that and going to be able to defend against that. That's something that I would always suggest making sure you're represented for. And this is just further explaining indemnification and what it entails, what it covers. It covers everything that is within the scope of the LLC's scope of business. And then we've got our miscellaneous provisions, the stuff that just doesn't really make sense in any of the other sections. It incorporates the entire agreement. If we want to amend this, then all the members need to consent, and it needs to be amended in writing. So any verbal amendments are not going to stand. If you want to make amendments to the rules of your LLC, we need to definitely sit down and do a revision to the operating agreement. It can be executed in multiple parts. Notices are going to go to the registered agent, But any notice that any member would provide to one another, to another member, would go to the address that's going to be listed in the Schedule A. You can list that as the registered agent address, or you can list it as your individual address. This document, the operating agreement, is not going to be like a public record of any kind. It doesn't get filed with any courts anywhere. This is something that is internal for you and your trusts. So it's okay if you put your address on the operating agreement, because the only people who are going to access it are people who it's given to, people who you give it to them. So if you need to send some kind of notice to the trustee, or the trustee needs to send some kind of notice to you, you can absolutely use the registered agent, or you can use your personal address. It doesn't create any issues with the anonymity, Secretary of State, things like that. It's structured under Tennessee law. It's a Tennessee LLC. And then, of course, severability. We want to make sure that if any part of this operating agreement is found to be invalid, it does not invalidate the entire agreement. And then the final section here is the definitions. This is standard. It goes into what we mean when we say additional members or capital accounts or the word company. What are we talking about in this document? So it's the definition section of all the key terms that are just used throughout this document. What do we mean by these terms? Finally, we have the signature page. The signature page is going to have whoever the trustee is for the revocable trust. So it might be John and Jane Doe. It might just be John Doe. As long as one representative as the trustee for this trust signs, then it's good to go. It has the trustee for the asset protection trust. In this case, it is myself, because I'd be serving as trustee for the JD and JD Irrevocable Asset Protection Trust. And then we have the members as individuals. So this all needs to be executed. It doesn't have to be executed all at exactly the same time, but it needs to be executed within a day or so of each other, ideally. This is back to that Exhibit A. This is where the addresses that I was referring to, where you would receive notice, you could use your personal address or what have you. This is where I'm referring to that. So we will put addresses here. And then the last thing we're going to talk about is Exhibit B. This is very crypto specific. It incorporates the crypto addresses into the LLC to ensure that the LLC owns these assets. This will be a living document. You want to make sure that whatever addresses you acquire or whatever you're starting off with are entered here. So it can be revised and added and removed and deleted and changed however it need be. But you want to make sure that whenever you edit and revise and change this, you note on other copies and older versions that those are no longer valid. So you go back in and you do a big slash and write the word void across the top of that. You maybe date the document showing the progression of the changes of when things were added and subtracted, so that we don't end up with 10, 20 different versions of this document and don't know what addresses are correct.
Crystal, I've got one comment there, just having seen this play out before. For one, and Crystal will tell you this from her real estate background, with certain assets out there, there's a very clear process for how you title them, let's say in the name of a business. It's very regimented. It's very specific steps that go into that. For cryptocurrency, as we all know, that doesn't exist. There's not a way to say that this piece of crypto is owned by this particular business in a formalized manner. So what Crystal's going over is really a workaround that is really, to her point, just a documentation of what you have added and are attesting has been added to this LLC, this business. I've seen that change a lot with MCA clients in the past. They'll set up new wallets. Some of them have a lot of stuff in them. Some of them have very little. But it's like you said, Crystal, it's very much a living document, especially this exhibit. I don't think it's in your best interest to inundate your attorney with every change specific to this, because that's going to have an expense associated with it. And Crystal, if you got any thought there in the contrary, let me know. But I think what you described is perfectly sound in that you need to keep this up to date and very clear on what is inside of this entity from a crypto digital asset standpoint and what's not, i.e. removing stuff, writing void, everything Crystal said there. Anything to add to that, Crystal?
Yeah, Blake is exactly right. You don't want to send every time that you buy or sell or change an address, you don't want to send that to the attorney. There's going to be a charge for that in reviewing that and updating your document. So it's just an unnecessary expense, and it doesn't affect anything on the legal side for us. So I would not suggest doing that. It is perfectly sufficient to just keep track of it on your own and view this as more of a table of contents or a reference document, if you will. Because, Blake, I think you said this already, but let's say you go in and you add some address on here that you end up never actually buying. Just because you've added it on here doesn't mean you actually own it. It doesn't mean the LLC actually owns it. So this document doesn't have any true ownership effect. It doesn't actually make you own that crypto address. This is more of a reference document that says these are the addresses that should be accounted for. These are the addresses that we have done the outside process of whatever purchasing that asset looks like. We have done that process. These are the addresses that our trustees and our LLC members should be aware of us owning. So it's not something you need to update.
Yeah, I agree. I think, at best, this is just a documentation and a way to organize the different digital asset addresses that are associated with this LLC. As Crystal said, there's really not a technically legal way to say that anything owns a wallet, an address, other than those that have custody of it, kind of by default, right? So the intent and how this is laid out is this is the closest thing to what we could try to say is ownership by the LLC, which is kind of the intent indirectly, right? It's how the taxes flow through as well. Everything's reported through the LLC. But at the end of the day, I think the point that Crystal and I are trying to make is that this is not a standardized process that is regimented like many other assets that we have dealt with in the past, real estate specifically. So I agree with everything you said there. I don't have anything to add to that. Okay, so the next trust we're going to discuss is the Charitable Remainder Trust. Crystal, if you can start by walking us through the first couple articles here, and then we'll talk about the tax benefits. You've already watched the video that goes over a lot of the tax calculations. Today, we're going to focus on the actual provisions of the trust and how that ties in. So, Crystal, if you want to go through the first two articles, and then I'll pick back up after that.
Sure thing. So, the Charitable Remainder Trust is an additional type of trust that we offer. Like Blake said, you guys have already heard about that. You've already watched the video and learned a bit about it. So this is what that trust looks like. Similar to some of the other trusts, you're going to be the trustors of this trust, and then you will have to have an independent trustee, such as myself, serving in that position. The identifying language of the trust, it's known as the JD and JD Charitable Remainder Trust. Or Crystal Henry, trustee of the JD and JD Charitable Remainder Trust. So this is just like the other trusts. Same thing where it incorporates the date into the title of the trust. A lot of these are the same sort of boilerplate sections as the Asset Protection Trust, the Revocable Trust. There's a lot of different language in here that pertains specifically to this being a charitable trust, but those are going to be really in specific sections of their own. So all of this just states that the trust is irrevocable. It is the trustor's intent to create an irrevocable trust. It outlines any transfers to the trust, which is the same thing, just retitling and moving assets over into the trust to be owned and held by the trust. Article 2 goes over trustee succession and the investment advisor or trust protector, excuse me. So the successor trustees, we have that a trust protector will appoint a successor trustee, just like in the asset protection trust. If there's no trust protector, then it could go to the court to get a successor trustee appointed that way. All of this is the same language. We have the same thing set up to where the way that you have a trustee appointed, a successor trustee appointed, a co-trustee appointed, any corporate fiduciaries who might assist in serving with the administration of this trust if a trustee deems it necessary, what happens in the event of incapacity of a trustee, any provisions regarding independent special trustees for a specific purpose. All of this is the same language and structured the same way with the same instructions as the asset protection trusts. Removing and replacing trustees, same thing. Rights and obligation of investment advisor. Again, the investment advisor is someone who serves in sort of a financial advising role and position, who assures that the trust assets are not just sitting stagnant, and they advise the trustee as to the best way for the trustee to make sure that the assets of the trust are growing. So all of their rights, powers, obligations, fiduciary duties are the same as that of a they're the same as that of an investment advisor in another type of trust. So they will be doing those same types of things. We will designate your investment advisor. Here we've got Bison. Bison can absolutely serve as your investment advisor. That's who we default to working with. If you want to use your financial advisor, we will just ask that you make sure you check with them that they are comfortable in serving in that position for a trust. And we can list them and name them here. So all the same thing. This is all very familiar. That's why I'm kind of just blowing past it. It's the same information that you've already seen in previous trusts. If you want further information about each of these sections, go rewatch the asset protection trust section. I do go a bit more in depth with each of these, but otherwise, just for the sake of time, I don't want to go too in depth with every single provision we've already gone through. The trust protector. This is again the same as the asset protection trust. Designating a trust protector is something that is the trustor's choice. That position is the same as it is in any other trust, where the trust protector acts in the best interest of the trustor to ensure that the trustee is acting in alignment with the trustor's wishes and goals as they understood them to be. So the trust protector can hire and fire trustees. They can ensure that the trustee is upholding the wishes of the trustors. So the best person to appoint in this position, just like in any other trust, the trust protector is best a family member, close friend, but it can't be someone who is the beneficiary of the trust. All of these terms are the same as the prior trust that we went over. Removing a trust protector, if a trust protector resigns, what happens if the trust protector is incapacitated? What are their powers? What are their obligations? So all of this is standard kind of boilerplate information about the trust protector position. So next, this part is a bit more specific to the charitable remainder trust, and it's really specific to the tax portion and the tax benefit of the charitable remainder trust. So I'm going to actually hand this off to Blake to go over and discuss with you guys.
So we'll keep it high level because we've gone through up to this point a lot of the tax benefits of the charitable remainder trust. This particular section outlines how the charitable remainder trust pays out to you, the trustors, or whoever you designate as the non-charitable beneficiary. And that's really what section 3.01 says, is it's going to pay to these people for this amount of time. There's some optionality there that we'll go over, but generally it's either for the life of one or more beneficiaries, or it's for a set number of years. And that's an option of you, the trustor. Section 3.02, determining the unit trust amount, is part of that tax calculation and in part what you're trying to target from a cash flow standpoint. We already reviewed that the way these trusts work is they pay out a percentage of their fair market value each and every year. How that's split up, quarterly, monthly, annually, is up to you, but it is a fixed percentage based on the fair market value as determined at the beginning of each year. Now that fixed percentage has to be a minimum of 5%, which is why we've got 5% in here, but it can be a percentage larger. The limiting factor as to how big that percentage can be is not your choice or ours, it's the IRS's choice, and it's based off of certain calculations, which really get to how long the trust is going to be around and some rules that have to be followed there. So we'll work with your attorney to make sure that those options are known. But this is basically the percentage that the trust will pay out each year, regardless of how it is split up throughout the year. If you can keep going down, a lot of the rest of this is boilerplate. There is some proration if it started mid-year. There's some math that gets to calculating what the percentage should be if it's not a full calendar year. You can keep scrolling there, Crystal. Thank you. Additional contributions, they're allowed. They need to be approved by the trustee. What it does when you do make an additional contribution is it requires us to take into account the fair market value of whatever you're adding, and to then adjust the distributions based off of that. And that's what section 3.05 really articulates. And especially if you add whatever it is you're adding mid-year, there's some calculations that have to be done to change those payments based on the change in trust value. And those contributions can be done while you're living, after you pass away, if this is not something tied to your life. Section 3.06 gets to the frequency of payments. We default monthly, just because that's the preference of most folks that set these up, is they like the idea of a monthly check coming in. But again, that can be any frequency that you desire, monthly, quarterly, semi-annually, or annually. And then excess income, any income of the trust for a tax in excess of what it should be paid out is just added back to the principal of the trust and maintained as its value for calculation on the next year. So that's it for section 3. I'll make one comment, and Crystal's going to go over some stuff after we get through the charity piece here. If this trust is not set up for your life, i.e. it's set up for a certain number of years, we're going to talk about that in Article 5, and that's where you really need to have contingent recipients of that income in the event that you pass away before the term of the trust ends, because that trust has to continue to pay out until it is set to end. Most folks we work with set up charitable trusts that are tied to their lives as a way to get an income stream through either their passing or the second death of them and their spouse. And that's when it's in. So that Article 5, which we'll review in a second, becomes less relevant in the case that it's ending at the moment the second dies, or if it's just tied to your life, you die. There's no need for a contingent beneficiary there for the recipient of payments. Distribution to charity. The whole premise of a charitable remainder trust is, in effect, you as the trustor making a promise to give money to a charity after the trust ends. And you're getting a tax deduction for that in the year that you contribute property to the trust. Article 4 outlines that promise, saying that distributions to charity will happen after the termination of that unit trust period, which is tied to the term of the trust. What essentially happens is everything that's left in the trust pours out to one or more nonprofit organizations that are registered with the IRS. That's what the entirety of this article outlines. Section 4.03 allows you the right to choose who's going to be the recipient of those charitable proceeds. And you can outline that on Schedule B. And like I said earlier, it can be more than one nonprofit that you're granting these funds to upon your passing or upon the termination of the trust. You can accelerate charitable remainder designations in certain cases, and that's outlined right at the end of Article 4. But everything in this article is all about that promise that's being made, which is what keeps the tax deduction intact that you're afforded by putting things into this bucket, if you will. It's a promise that those things and whatever's left over will eventually go to a 501c3 organization. That's it for Article 4. Crystal, if you want to take over with Article 5, I kind of jumped the gun a little there with the recipients piece of it.
Yeah, no. So Article 5, it kind of gets back into more of the legal administration side of how the trust is handled and how it's administered. So what happens in the event that there's incapacitated recipients? Like Blake, you had mentioned earlier, if you want to talk a little bit more in depth about that real quick before I go into this, what happens in the event that it needs to circle back and have contingent beneficiaries?
So if the primary beneficiaries, generally the trustors, the non-charitable income beneficiaries, as it's typically referred, pass away, and the trust is tied to that person or those people's lives, then there really isn't a need to have some alternative unit trust recipient in place. The trust ends with their life. Now, if it is a trust that is set up for a certain number of years, which is the other option here, hey, I want to set this trust up for 10 years, regardless if I live past that or if I die before it, that trust would have to continue for however many more years after the life of the trustor or trustors. And in that situation, it is necessary to articulate, and it will also be in Section 3, who would be the recipient if the primary unit trust recipient becomes incapacitated, passes away. Now, if they become mentally incapacitated, payments are still there for their benefit. They just may be going to a party that they're sent to on their behalf. Very similar to what Crystal has spoken about with other trusts in the event that a beneficiary is no longer mentally competent. So a lot of what's in this article is probably most applicable to a trust to where there is a term of years tied to it, and the potential that the unit trust recipient passes away before that term ends. But it also covers other situations like, incapacitation for purposes of mental competence. But like Crystal said, a lot of what's in here, and she'll go through it real quick, is in line with at least conceptually what we've seen in these other trusts. It's a rule book on what happens if you, the trustor, are no longer competent, is the short of it. Does that help, Crystal?
Absolutely. So like Blake said, that's the goal of this article, is to make sure that in the event that the actual beneficiaries that you've designated are not around to receive the beneficiary distributions, what do we do with those? And then this covers how we handle those distributions, so that it has to go directly to the recipient. That's discussed under the distribution methods. If the recipient is incapacitated and under some kind of guardianship or conservatorship, it could go to the guardian or the conservator or a family member who's caring for that minor or incapacitated individual. So a lot of this language, you'll notice, very similar to the prior trust as well, because we do handle these types of distributions to contingent beneficiaries. We handle them the same. It's the same sort of rules, that you're supposed to give only distributions only to the beneficiary themselves. But what do you do in the event that they're incapacitated and they're not able to accept that? It can go to their guardian. This is what allows for that to be an option. Article 6 continues on to really go more in detail about the way that the trust is administered and handled. It's got the same type of standards regarding computing the fair market value that has to be done and monitored in order to make sure that the market value is correct for valuation each year. Private foundation restrictions. There are some specific restrictions as to what type of foundation you can donate to. So those they'll go over with you whenever you're picking your charity. Other payments are prohibited. This strictly is going to be paying out the unit trust amount to the beneficiary, and then the remainder to the charitable organization. The rest of this is boilerplate. We don't use this trust income to satisfy other obligations of the trustor. The distributions have to go directly to the beneficiaries and must be made only by the trustee. More kind of standard language. We want minimal court proceedings. We don't want a bond to be posted in order for this trust to be administered. That just ties up assets of the trust, and then it wastes time and assets and money in court proceedings. So we waive those as much as possible. Standard trustee administration language, indemnification language for the trustee, compensation language for the trustee. It's the same standard that we use for all of our trusts of the fair and reasonable compensation amount. Employment of professionals. It allows the trustee to bring in any professional in a particular field that they might need assistance with in administering the trust. Determining income and principal. It is the same procedure that's used for all others, as there's valuations done in order to determine how much income the trust made and what the principal balance is. Trust accounting. The trustee must render accounting at least annually. This is the same requirement as the other trust, just making sure that the trustor and the beneficiaries are kept apprised at least annually of what's going on within the trust, what kind of money movements, what kind of interest has been earned, any other kind of income, that sort of thing. The rest of this, pretty boilerplate stuff. It's all kind of repetitive of the Asset Protection Trust. I feel like a broken record saying that, but a lot of it is very similar as far as the administration goes. It's trustees serving in trustee capacities. So a lot of it has to say the same thing in order to cover the trustee's position. This is, again, going to be very similar to other trusts, the trustee's powers. It's a little bit different here because the trustee is not so much doing what they do with the Asset Protection Trust, where, for example, a beneficiary would call and request a specific distribution amount, and the trustee weighs the HEMS standard, Health, Education, Maintenance, Support, against the assets of the trust and determines whether or not to distribute it. That's not really the case here. What goes on here is the set distribution amounts based on what Blake talked about earlier with the unitrust amount. It's the trustee's job to ensure that it goes smoothly and that it's done in a timely manner and that the accounting is done for the trust and the valuation is done and the fair market value is found out. That's the trustee's job and power and position there. Otherwise, it's all the standard trustee powers. Banking powers, they have access to the bank accounts. Business powers, they are authorized to serve as the director and manager of the trust or anything that has a trust interest. Contract powers, investment powers, these are all just standard powers of the trustee. They're statutory powers of the trustee so that they are able to perform their position as trustee in the event it should arise. Insurance powers, loan and borrowing powers, nominee powers, oil and gas powers. All of these we go over in a bit more detail in the asset protection section, but same thing. All of these are about allowing the trustee the ability to perform their trustee duties as necessary. So investment obligations of the trustee, this does say that the assets in the trust shouldn't just sit stagnant. It should be the assets in the trust should be earning income in some way. That's where the investment advisor comes in and advises the trustee how to best accomplish that. And then Article 8 here, this is the general provisions, and it is, again, the same as the Asset Protection Trust provisions. The spendthrift provision, we want to make sure that no one's taking advantage of the trust. The contest provision, anyone who contests the trust could potentially risk the ability to take as a beneficiary under the trust. Governing law is Tennessee. And then definitions of the trust, this is the same, well, not the same definition section, but it serves the same purpose where it defines frequently used terms within this document. What is a taxable year? What is considered trust property? What is the unit trust period, etc. The general provisions, same thing. Severability. All of that is the same as the Asset Protection Trust, and we went in detail, so please go look back through that if you want to know further, or if you want further information about the general provisions as well. That gets us to the signature pages. This does need to be executed by the trustor in front of a notary Jane Doe is the other trustor here, so she must have signed and notarized as well. And then the trustee has to sign. So the trustee doesn't have to be present while you are signing, but the trustee will sign as well, accepting the position of trustee. Something that was mentioned earlier is Schedule A, Schedule B, and Schedule C. So Schedule A is just like the other asset protection trusts, where you keep this sort of living document. And as you transfer assets into the trust and retitle things and move money into the trust, you keep this as a record and a log so that the trustee knows this is what's supposed to be in here. Schedule B is referenced, actually, Blake referenced it in Article 4. This is where you designate your charity. You can have more than one charity, but this is the information that we'll need at the very minimum, their address and their EIN. But this is the information that we'll need for the charitable trust, or excuse me, for the charitable interest where you want that to be paid out to. And then Schedule C, designation of final charitable interest. It says C attached, and there's this document here. This is something that you will fill out regarding specifically how you want that to be designated and where you want that to go.
I've got one comment there, if I can, Crystal, on this from a tax standpoint. So the final designation of charitable interest is essentially what locks in the designated charitable party or parties, whoever that may be. There is some flexibility, and it says it throughout the document, for you as the trustor to change who the charitable beneficiary is, to name one and then add another, or to change them altogether at any point. Now, I will tell you from a tax standpoint, the best situation is for you to pick the charitable beneficiaries in the beginning and not change them. If you change your charitable beneficiary, it creates some issues that may require, not always, amendment of tax returns. And we can get into the why there, but it gets to the fact that you would likely take a charitable deduction that could be limited based on the nature of the charity you are designating in here. And if you change the nature of that charity, we may have to go back and work through adjusting the tax return based off of different limits. So this final designation of charitable interest is what locks it in. Once it's on here, it cannot change. You're locking it in, and that is the best situation from a tax standpoint, is that this is locked in day one. But if you're not sure on which charity or charities you would like to be the charitable recipient, or if you feel like it would change, then there may be good reason not to do this, but it may create some tax considerations there from when you take a deduction to whether or not an amendment would be needed if you changed it in the future. We can talk through that. But again, the best situation is for you to name who you truly intend to receive the charitable proceeds once the trust ends out of the gate. That was the only thing I wanted to add there, Crystal.
Awesome. No, that's great. That gave further explanation as to this document. So this does need to be signed in front of a notary as well. So whenever you do execute this, make sure that you execute it in front of a notary if you don't choose to do it at the time you're signing your trust document itself. But that is it for the charitable remainder trust. Make sure you write down any questions and save those questions for your drafting attorney to go over during your delivery and revision call.
Is there anything else, Crystal, you want to leave as far as guidance is concerned based on you and your team's work?
No, I'm glad that you took the time to watch this video. Like Blake said, this is the precursor to your delivery video. It's very important that you come to that video, or excuse me, to that call, having watched this video with an understanding of what documents you're looking at, and ask pointed questions and make pointed edits and revisions so that you can make the best use of that time on that call. So thank you for your time and watching this video. It really helps the process run smoothly.